Excuse me. 29. No.
May I please, Your Lordship? I beg to mention item 27.
Why do you want an adjournment? Why do you want an adjournment?
Lordship to file affidavit in opposition.
Counsel, you are for?
Guwahati High Court, Lordship, on behalf of Mr. Yukenai.
Okay. And counsel MS so and so assisting Mr. Yukenai,
Yes, sir.
senior advocate, appearing for the Guwahati High Court command. Praise for time to file affidavit.
It's ready, my lord. Within 2 weeks, I'll file it. my lord.
List up to 2 weeks. Affidavit on behalf of the respondent.
May I please, my lord, one writ petition, my lord, criminal in the form of my lord habeas corpus. My lord, may I pray, my lord, can it be, my lord, taken up at 2, my lord, today?
Why at 2?
Because, my lord, illegal detention since, my lord, 25th of this month. The minor baby also, my lord.
Tomorrow.
Developed.
Tomorrow.
Lord,
Give an advance copy to the state council.
Lordship, item number 22, Lordship, an affidavit has been filed yesterday, so it may not be on record, Lordship. Lordship may kindly call it for.
Mr. Kalita, so you want it to be called now?
Yes, Lordship.
Call it.
Item number 22, Lordship.
Call it.
Lordship, in connection with item number 35 and 36, on last occasion, Lordship has directed to list the review petition along with this case. I got the
Review.
review petition we have filed. The state has filed a review. Well, the review has been numbered. I have the number, my lord. I am giving a mention slip so that the same thing is numbered.
Right now?
Today, it is already numbered.
अभी देख लेते हैं आने दीजिए. Call the review here. Yes.
May I please, your lordship? In item number 29, that is listed, I will pray for calling of 2 petitions, my lord. The connected petitions. What happened in this matter? The virus of the Karjanglong Land Revenue Act has been challenged.
Virus.
Virus, yes.
Virus.
No, my lord, yes.
Coronavirus.
Virus has been challenged. I have interim order is there in my in favor of us petitioners. But in spite of that, today morning I got a call from my clients that 144 has been imposed and they are going for eviction. My lord, they have done in earlier occasion a contempt petition is pending. So my lord, kindly call for those connected matters at 2 p.m. my lord.
Call it.
My lord.
May I please, Lordship? Lordship, I would like to pray for a listing, my lord.
Obliged.
An appeal, my lord. On
Appeal.
appeal, my lord. On tomorrow, my lord. Matter pertains to settlement of the fishery, my lord.
What is the date of the SB judgment?
Lordship,
What is the date of the single bench judgment?
22/5/2023, and we have
Tomorrow.
received a copy.
Tomorrow.
Yeah, please, Your Lordship. I pay for listing of interlocutory application for stay vacating, my lord. Already numbered, my lord. My lord, day after tomorrow, my lord.
Day after.
My lord. Highly obliged.
Daily list for this item 1.
Very long drawn out litigation. Long drawn out litigation. Yes.
The lordship has produced the office note, lordship. It seems that it appears that respondent number 8 has not yet been served, your lordship. Service has not been completed, respondent number 8.
Respondent number 8.
Lordship.
Pending for service since 2016.
Lordship, we'll take fresh steps, your lordship. We'll take fresh steps by tomorrow, your lordship.
Which office note? This has never been pointed out
No.
that the service is still not complete.
No.
Where do we get it from, sir?
It's an order of 2020, your lordship. What I.
What is this? That no one has ever pointed it out. The service is not complete.
Letter from them.
Letter from respondent number 8.
No.
They have given a note on their status.
So then they are basically not a contesting party. There's some letter received from that respondent number 8. Indian Institute of Plantation Management. And they probably have just given an opinion. So they would not be contesting, it seems. So since they have sent a letter, service can be presumed to be complete.
Whether they can keep the price.
Fix the price or not. Precisely. So what do you want now?
The lordship, in that
Argue-
case, if service is complete, lordship can fix them as per admission.
The respondent number 8, though not. Though service of respondent number 8, the proof of service of notice upon the respondent number 8 has not been received, but we find available on record, a letter dated 6 June 2019, forwarded by such. Forwarded to the Assistant Registrar Administration, responding to the present writ petition. Otherwise also, it seems that the respondent number 8 is not a contesting respondent and seems to have been impleaded just to seek its opinion. The opinion has been forwarded in the letter. Thus, service upon such respondent is deemed to be complete. List. When do you want?
After 2 weeks, your lordship.
List for final disposal after 6 weeks, as per it. Copy. You have a copy of this letter?
No,
Copy of the letter dated so and so be provided to learned counsel representing the parties. Registry shall provide copy.
Item number 2.
Also, this matter is with regard to reforms in jail. The set of directions were issued by the Honorable Court on 15/12/2022. Pursuant to that direction, states Arunachal Pradesh, Mizoram has filed affidavit. Also,
have filed.
Nagaland has said that they have filed affidavit. I haven't received a copy of this.
You have not received. Okay.
And so far as state of Assam is concerned, some press reports are filed. Perhaps it is there in the records before your lordship.
The reports of Assam are not available.
I have received inspection report in respect of 15 jails.
Hmm.
Altogether 31 jails are there. The inspection team is conducting the inspection. It is not complete. The inspection reports of 15 jail, I have handed over a copy.
You file it properly. File it on record with the NFA.
Lordship,
It is better in the record.
Lordship may kindly.
What is the report submitted by the member secretary? What is that report? Let us see.
That is the inspection report.
Okay.
Jail inspection report.
When was their inspection made?
Inspection was they are in the month of April and May. They inspected 15 jail.
May.
Date of visit is, they have mentioned the date in the month of March, April, and May also.
For the time for some job report complete inspection. Visit, presence. Scheduled visit time. Still continue.
There was 15 completed, 15,
Hmm.
16 is leaving. Let them
Yes.
complete the forms and-
Learned counsel, Mr. Nath, appearing for the prisons department. Submits inspections have been completed by the committee constituted for this purpose of 15 prisons, and 16 prisons still need are to be inspected, and the inspections have been scheduled
They said in the month,
in the coming days.
in the coming days.
He prays for and is granted 4 weeks time to file the reports after completion of inspection. After conducting inspection of all remaining prisons. In the meantime, the report dated 25th May 2023, forwarded by the Assam State Legal Service Authority, shall be, copy of the report shall be provided to learned my custody.
I have.
You already see
Yes, already served upon me.
list after 6 weeks.
Item number 3,
Much obliged. May I pay your lordship? My lord, as per office note dated, my lord.
Respondents numbers 2, 4, and 5
Yes.
not served.
For one and two, my lord, we have filed.
You are appearing. 4 and 5
4 and 5, my lord, I will take a place.
and counsel, Mr. Goswami appears for the respondents numbers 1 and 2.
Yes, ma'am.
Thus, counsel for the petitioner to take fresh steps for service upon the respondent number 4 and 5 within 7 days, whereafter process will issue. Attendance, or you give your names. List of 6 weeks.
item number 4 to 7,
Yes.
Regard to item number 4, Lordship. The brief has been earlier handled by Deputy Solicitor General R.K. Dev Chaudhary, Lordship, but that brief has been handed over to CBI. It was not available in the record, Lordship.
Today the matter comes up for orders on an interlocutory application filed by the CBI
Yes.
seeking leave of this court to register regular case.
Right.
Why do you need a leave?
No, because earlier there is a direction from this honorable court.
To make an inquiry.
Yes, Lord.
All right, you made an inquiry. Cognizable offences are disclosed.
Lordship,
Register the FIR.
enquiry has been made. And it was placed before this honorable court and thereafter, Lordship,
Mr. Counsel,
Lordship.
the CBI is competent to register a case.
Right, Lordship.
It is already making a plea has been made.
Right.
Offences are found made out.
Right, Lord.
Register case, what stops you?
Yes, Lord.
Then what do you say, sir, gentlemen?
Yes, well, I am appearing for item number 6 and 7.
All right.
My lord,
Order kar dete hain na isme.
for the state of Arunachal Pradesh.
Okay.
Yes, my lord. In this case, what happened, my lord?
There are
4
judgments.
and 5, no copy has been, we are not the party.
We'll not comment about that. I've read. IA number so and so has been filed by on
And
behalf
my
of.
lord, for the, may I submit, my lord? For item number 6 and 7, my
For
lord.
the timing, we are with item number 4.
Yes, ma'am.
We'll call item number 6 and 7 later. Filed by the Central Bureau of Investigation seeking leave to register a regular case pursuant to preliminary inquiry conducted by effect of the orders passed by this court in the connected matters, that is so and so. A perusal of the application would reveal that after conducting preliminary inquiry, the CBI has found evidence, sufficient evidence, collected sufficient evidence revealing commission of cognizable offences by Shri Nabam Tuki, Srimati Nabam Maka, and Avinash Kumar Mishra. In this background, and since the CBI, which is seized of the preliminary inquiry, has collected sufficient material to register an FIR, we are of the view that no formal permission is even required. So,
My lord,
yes.
this case is interconnected with this case 6 and 7, my lord.
Mm.
May I submit, my lord? In this case, what happened, my lord? There is an order from this honorable court directed to take, my lord, consent from the state government, my lord.
Mm.
As state government has refused the consent, my lord. And against that order, the CBI has come, my lord. In the instant case, my lord, there is a judgment of the apex court, my lord. There are many party, my lord. They are not even served the notice. If your lordship go to the West Bengal judgment and the task of the Mayabadi.
For registering an FIR, why notice is required, sir? Tell us.
FIR has been registered, but consent of the state government.
Where the FIR has been registered? Which FIR?
Yes,
Tell
my
us the
lord.
number, RC number.
Yes, my lord, I am giving, my lord.
Yes.
FIR, my lord, 48 to 71 in, my lord. ISC bill, my lord, 1887/2020, my lord. Page, my lord, 48 to 71, my lord. This is the FIR, madam. In my
They are
case,
for different set of allegations. They are for different set of allegations.
this,
That is for a different allegation. This is for a different allegation. They will approach you. You don't grant them permission. That's a different matter.
yes, my lord. For this case, my lord, I am 1887. In this case, we are not the party, my lord.
So
State
that's
of
what,
government
that's what
authority.
we are saying.
Although consent is necessary from the state government, my lord.
So if at all, we will simply say that they are free to proceed as per law.
Yeah, therefore the proceeding. In case allegations are found having substance, warranting for the criminal person, may proceed in accordance with law.
We may observe that while passing the order for holding preliminary inquiry dated so and so, passing so and so, comma, this court has already given liberty to the CBI to proceed as per law in case the offences are found proved after inquiry. Thus, comma, the applicant CBI is given liberty to register the case in a regular case as per law.
Okay.
If these facts and circumstances, if the evidence collected during inquiry justifies registration of the regular case, IA is disposed of. Now 4 and 5, are you ready to argue?
Yes,
4,
sir.
5, 6.
Lordship. With regard to IA 1887, Lordship,
Mm.
1887. Here we have paid before this honorable court, as because consent was not given, approval was not given.
Mm.
Therefore, we have seeking direction from this honorable court.
Whether that is permissible.
Lordship, we have in page number 13 of this petition, we have cited some judgment.
Before starting is, my lord, actually state has engaged KN service senior to argue this case, my lord.
Mm.
The time being, my lord, he will come, my lord.
Time being password.
Not for this.
Item number 8.
Yes, yes.
Lordship, as per the last order, steps have been taken and the
Yes.
service has also been served to respondent number 6.
Yes.
And we have also filed an affidavit to that effect.
His service has been, anyone is appearing for respondent number 6, please?
Number one.
When did you file the affidavit?
Uh,
106.
Yes.
Yes, I don't even
Service has been effected on the respondent number 6. Till date, no one has appeared on behalf of such respondent. List for admission after 2 weeks. IAS, EST, IAS. List for admission after 1 week.
Obliged, Lordship.
Item number 9.
Again, service complete.
May please, my lord.
Yes, delay. Any objection? Condemnation of delay?
My lord, because my lord, of the reason, my lord, I was the writ petitioner, my lord. And there is an order, my lord, to formulate the law, my lord. If the delay is condoned also, my lord, even though, my lord, the very purpose will not serve. Instead of division bench order, my lord, if they are agreed, my lord, they ought to have gone to Supreme Court, my lord. But
Why?
without doing so, my lord, there is an order of this division bench already, my lord, to formulate the law. And that one, my lord, the chosen pick-up policy to remain, my lord. So if necessary, my lord, we'll file our objections, my lord, 2 days.
If necessary means what? You have not filed it till date.
My lord, it was brought on mention, my lord.
No.
It was on by order, I say.
What was brought on mention?
By mention, they brought the case, my lord.
Listing is by mention,
By
no?
mention, my lord, by,
No.
by order, my lord.
There is no mention. The registry has fixed it.
But causely so, my
Mention
lord.
memo, yes.
It was mentioned.
So how does it make a difference?
So lordship, give me at least 1 week or 10 days time, my lord.
Council, Mr. Your good name, please.
J.I. Borbia for private response number 4.
Private respond number, Mr. J.R. Borboya, appearing for the respond number 4. Praise for and is granted.
2 weeks.
2 weeks time to file reply in the IA number so and so.
Lordship.
Objection in the IA number. So and so.
In there is a 2 IA, my lord. One is seeking leave and another is a
In as well as IA number so and so.
lordship.
Both.
Obliged, my lord.
Once obliged.
Item number 10.
Condemnation.
My lord, may I please, the lordship, my lord, 335 of delays, my lord, and there is a private respondent is there, my lord.
What is the justification for delay?
My lord, we have narrated in paragraph 6, 7, and 8, my lord. Some medical ground as well as, my lord, some time taken to take a decision, my lord, to prefer the appeal, my lord.
Notice.
My lord.
Who is appearing?
I am for the state, my lord,
Mr. So for
education department.
Education Department, response numbers 1, 2,
One,
1 and 2, 1, 2 and 4,
yes, ma'am.
1, 2, 4 and 5.
Five also.
Five also.
Number 3, Madam M. Bhattacharya for respond number 3. The steps for service upon the respond number 6 be taken within 3 days, whereupon process be issued.
Will I be permitted for Dusty also?
Thus, the service is permitted.
My lord.
Rule is made returnable in 4 weeks.
File an affidavit.
Obliged, lordship.
Item number 11.
Lordship, there is a delay of 63 days in preparing the writ appeal, lordship.
Notice, or issue notice to the respondent. Steps for service be taken within 7 days, whereupon process be issued. Rule is made returnable in 6 weeks.
Much.
Shivan Prakash.
Item number 12.
Yes, what is wrong in the order? The appellate authority says no new facts have been brought. Why in appeal new facts are required? Your appellate authority does not know how to decide appeals. So why shouldn't we direct disciplinary inquiry against the appellate authority for dereliction of duty? Is a new fact required to adjudicate an appeal?
No, my lord.
Read the appellate order.
My lord.
And remember your statement, no new fact is required. It's a reappreciation of facts passed by the adjudicating authority. Appeal is a challenge to the order of the adjudicatory authority or the disciplinary authority.
Hello.
Why is the appellant employee required to bring new facts on record?
My lord, we are bank, my lord.
We are?
Bank, my lord.
Yes, so
So, my lord, what has?
bank has its own procedure for deciding appeals, contrary to the normal principles.
My lord, the principles of.
Read the appellate order, page.
Read out the entire order, my lord.
Appellate order, page number.
89, my lord.
Read. What are the reasons assigned? Concluding part.
So, para 25, my lord.
Yes.
A further question which remains as to whether after obtaining the enhanced limit without appropriate application would be an act of misconduct or.
Para, what are you reading?
103, my lords.
103.
Please.
We are asking you the appellate order of the
Appellate
appellate authority.
Seventy-four, my lord,
Yes.
which has been set aside, my lord. I have gone through the points raised in the appeal dated 6/3/2012, preferred by Shri Hariram Dharikar, MGS 2 so against punishment of dismissal in terms of rule so and so by the authority and general manager by order dated so and so. In the alleged that the said Hariram Dharikar was working at CRPF Amir Gong branch during the period 23/8/2006 to 10/12/2009, committed certain serious irregularities. Shri Dharikar unauthorizedly overdue his personal loan account. It is also alleged that Shri Dharikar was involved in fraudulent withdrawal of 60,000 perpetrated by Shri Pijus Kanti Biswas, special assistant.
These are all facts
My lord,
mentioned by the disciplinary authority.
my lord.
Come to page 78. What are the reasons assigned? How is the discussion made?
The main charges proved under Dharikar in the inquiry conducted in the matter. Unauthorized.
Come below that, the appellate authority's mind application is in the para below.
The appeal for reinstatement does not.
The Sri Dharikar has not brought any new points in his appeal. What
New
new point is required?
Not required, my lord.
Then
That is true, my lord, but the fact remains that there was misappropriation of funds, my lord.
there was no, you did not find the charge of misappropriation proved. You only punished him for overdraft.
Yes, my lord.
Then how is it a misappropriation?
No, my lord.
He exceeded the limit of
Yes, from
OD,
5
lakhs to 7 lakh.
Ah.
That is the only charge proved.
There are some more charges which are proved, my lord. That is there in record, my lord. Page 58, my lord.
Read your own finding of the appellate authority.
The submissions made by him are devoid of merits. He has
The appeal for reinstatement so and so
does
does
not.
not merit a consideration in view of the above.
Yes,
So the finding is only regarding overdraft. Nothing beyond that. And then also, however, there seems to be no mala fide with an intention to cause deliberate loss to the bank. So if there was no mala fide intention, why the employees to be convicted?
my lord, that is why we reduce the penalty, my lord.
Oh, termination to renewal,
Yeah.
removal.
Ah,
That's wonderful. Very benevolent.
no, in the appeal, when he filed an appeal, my lord, what happened?
Gentlemen, how have you considered the appeal? We are asking. What is this reasoning? We are giving your notice to your appellate authority, Chief CGM. He
No.
doesn't know how to decide appeals.
No, my lord.
Yes, we are doing that.
My lord.
Then you tell us, Mr. Counsel, as a seasoned counsel of this court, is this a way in which an appeal is to be decided?
My lord.
Where are the arguments dealt with?
My lord.
Has he given any reasons, independent reasons for agreeing with the findings of the disciplinary authority?
Will pass order.
You want to withdraw? That is what the direction is. Pass a fresh order.
We may be given the liberty, we will pass fresh order.
What has this single bench done, sir?
My lord.
What has the single bench done?
Correct, sir.
We are asking you.
Now, single bench has again sent it to the.
So then why do you need another order from this court? So you want to withdraw?
One short date may be given. We'll take some instruction.
No, no, no.
We'll withdraw.
Then all right.
We'll
Notice to the appellate authority.
We'll withdraw.
Appellate counsel. As a matter of fact, this order should have been appeared. No, he's not here before. After arguing the matter for some time, come on. Then counsel, Mr. Your good name, please?
AK Sahiwala.
AK Sahiwala, representing the bank, submits that appellate bank submits that as the learned single bench has remanded the matter to the appellate authority to reconsider the appeal of the respondent, comma, it would be opposite to comply with the said order rather than questioning the same in this writ appeal. Thus, comma, he craves liberty to withdraw the instant writ appeal. Accordingly, the writ appeal as well as the interrogatory application are disposed of as withdrawn.
Much obliged.
Item number 13.
Yes, 13 cities.
May I please connect? Well, item
There are
number,
more matters.
item number
16,
13,
17,
18,
17,
all
18.
emanate from the same judgment, my lord.
Yes.
My lord can have 16, my lord. My lord, this matter will require an examination. The only,
There are more appeals which have been admitted.
Yes, my lord, yes. My lord, writ appeal
there are more, my lord, being filed by my friend only.
Writ appeal 156 of 2023, that was the first matter which had.
This court is apprised that analogous writ appeal number so and so involving identical controversy has already been admitted. Thus, all these writ appeals are admitted and they shall be tagged together. Respondents are duly represented. Thus, notice need not be issued. List for hearing. That's it.
Convenient date, my lord, because this matter can be thrashed out. My lord. It's a very narrow compass.
They'll come up, we don't know what is the date in the other admitted matters.
Lordship. My lord, can have the direct the registry to list it after a particular time, my lord.
Please the appeals for hearing after 6 weeks.
Lordship.
I'm obliged.
13, 16, 17, 18.
Conflicting.
16, 17,
18.
18. 1, 6. Adopt.
There's one reference by Justice Mehdi also. That's coming up, I think. Oh, land acquisition.
So,
No, he's person interest. He's enjoying possession. He'll get at this. The structures raised.
Otherwise.
So what is the meaning of this? What is the compensation? Term used as symbol.
Zira.
Zira. What is that? Zira.
Zira is a value of the houses, land, is.
Permanent property.
But it is not so that partial interest has been defined in that way. Not necessarily with the owner. Subject.
No, I agree. All right, let the matter be called.
Item number 14.
May I please? The writ petition was initially preferred against the speaking order passed by the department, my lord, dated 28/3/2019. Pursuant to the earlier round of litigation, there is an order dated 13/3/2019 passed by Honorable Single Judge in another case. And we had agreed by the impugn order, and that is another case is pending, writ petition is pending, WPC 2543/2019.
Before single bench.
Yes, before single bench is pending as of now. And in the meantime, these two persons have been aggrieved because their promotions process could not be concluded due to the operation of the impugn order. And therefore, they have preferred the writ petition before this honorable court, my lord. And during the proceedings of the writ petition, my lord, the honorable single judge has come to a conclusion that the service conditions of the petitioners, they are the khalasi serving in the PhD department, are regulated by the 1967 service rule, my lord. But the 1967 service rule in the schedule that the posts which are assigned are not covered the post of the PhD department. The PhD department has got various posts and they have got their separate set of executive instructions and draft service rule, my lord. It is not been given assent to, not published, my lord, but that they have been following this set of rules, my lord. May I take your lordship to page number 120? This is the draft service rule. And the annexure 3A, 3B, 4A, and 4B, these are the executive instructions. These are being followed for long days in the Department of PhD for the purpose of promotion from the grade 4 post to grade 3 post, my lord, of various categories. And your lordship will find at page number 121, the number of the nomenclature of the post. These posts are not covered in the 1967 service rule. These are the posts of the PhD department.
Come to para 10 and 11 of the impugn judgment. How do you dispute these observations
Yes,
and
sir.
findings? There is one division bench judgment against you, and there is one full bench judgment against you.
That is, my lord, with regard to, my lord, what happened, those posts which are
Read para 11.
As can be seen from the judgment of the apex court in the state of Himachal Pradesh Supra, there is no rule universal application that
vacancies must necessarily be filled up on the basis of the law existing on the date when the vacancy arose, and there is no obligation for the government to make appointment as per the old rules. When there is no statutory duty cast upon the state to do the same. However, the petitioner's counsel is not pressing this issue, as he lays emphasis that promotions would have to be made pursuant to the non-gazetted service rules. Well,
Read on, read on.
the non-gazetted service rules not having come into force in the state of Assam, I am unable to come to terms with the submission made by the petitioner's counsel that the said draft service rule could be supersede the Assam Ministerial District Establishment Service Rules 1967, which requires the minimum educational qualification of a person for promotion to a grade 3 post to be a graduate. Even otherwise, the fact remains that in terms of the law laid down by the division bench of this court in Dilip Talukdar Supra, which has upheld the judgments passed in WPC number such and such, persons who are regularized against personnel posts cannot be considered for promotion to cadre post when they are deemed to be holding ex-cadre posts. The division bench in Dilip Talukdar has held that a claim for promotion from a person holding an ex-cadre post was not legally tenable, and that promotion in Water Resource Department, Government of Assam, could be considered only from eligible employees in cadre post. Persons who are holding,
Mr. Pukas, have your clients been given the benefit of upgradation under the MSCP?
MSCP, they have been given, madam. Those who are
I
there.
feel happy. There is no question of, these are stagnant posts. That is why the government has come out with the scheme of financial upgradation. There is no scope of promotion. There is no, you can't help it.
My lord,
Isolated or stagnant posts. That is why that circular is there.
one thing, my lord, ultimately the posts are not covered under the 1967 rules in any manner, my lord. Because
In any event,
because, my lord, these posts are not there in the service rules, my
they
lord.
are ex-cadre posts.
Ex-cadre posts.
Yes.
And the promotional posts which they are supposed to be promoted, these are also not covered under the any rule, my lord. All the posts, either feeder post as well as the promotional cadre posts, these are not under any specific service rule, my lord. Had it been there in the under some specific service rule, I would have not checked at all.
You seek promotion in the Water Resources Department, right? And there is a channel of promotions provided in those rules. How can you stake a claim for promotion?
No, we are not in the Water Resource Department. It's in PHE department. It's not connected with the Water Resource Department, my lord. A separate department. They are running the department under separate set of executive instructions. For years together, they have been promoting. Had there been any specific rule for the even for the promotional cadre, I would have I would have been covered by the judgment of the full bench and the Supreme Court also.
This is the fourth round of litigation. I have been reiterating this again and again. Dilip Talukdar's case, madam. And they have not challenged their original regularization post or orders, madam.
In this case, I think
they are also same category. They were grade for, they are regular grade for employees. Regularization is. What is that? All right, we'll hear them admit. The respondents are represented by standing counsel of each department. Thus, notice need not be issued. List for hearing. Yes. List the matter for hearing on its turn.
Item number 15.
May I plead your lordship? The appellant preferred this appeal against agreed by the single judge order, my lord, which is at annexure I, page 111, my lord. And authority party is that 113, my lord, bottom in the Assam Educational Provincialization of Service of Teachers and Reorganization of Educational Institute Act 2017. as amended in 2018 has come into force on 5/5/2017, except section 4 and 8 of the said act and is applicable to only those whereof the service of teachers have not been provincialized under any act enacted by the state legislature and which remains as a venture educational institute and fulfill the eligibility of for provincialization as provided under the provision of said Act 2017 Act. But in this case, the said Dolgovinda ME School Baksa was provincialized under the provision of said Act 2011 Act as amended in 2012 during its force, and the 2017 Act does not prescribe any such provision for provincialization of teaching staff of any such school provincialized under the provision of 2011 Act as amended in 2012, and for those who are left out from provincialization during the course of the said 2011 Act. Considering the above, no such direction can be issued to the respondent authorities by exercising the power under 226 of the Constitution of India to
Yes.
provincialize the subject. Here the petitioner was not provincialized. Under this act, those schools already been provincialized.
You have been given liberty to approach the tribunal. Go
Yes.
there.
But my lord, here the section 4 and 8 was, except section 4 and 8 is acceptable is there. But section 4 and 8 only stated that teachers and tutor to be governed by the government servant. And 8 is the terms and condition of service.
Madam, you have been relegated to approach the tribunal for redressal of your grievances. Go there. What stops you from doing that? That is a statutory remedy.
Yes.
So avail that remedy.
But there is an office letter, my lord, page 22, where the petitioner can
Then what? At best, we can say, madam,
Yes.
if you approach the tribunal will decide your claim without being influenced by the observations made in the single bench order.
Yes,
That is
my lord,
what we
that
can
I
say.
understood, but there is an office memorandum and page 24, my lord,
Yes.
where the commissioner and secretary of the government of Assam, deputy commissioner, implementation of Assam Education Provincialized Service of Teachers and Reorganization Education Institute at 2017, where it was clearly stated that the teacher whose education institutions have already been provincialized as per the Assam Venture Education Institution Provincialized Service Act 2011. But their services have not been provincialized, may submit their application for provincialization of their service under new act. So accordingly, the petitioner has submitted.
Madam, all right. The authorities have not accepted your prayer. There is a remedy available in law.
Yes, my lord.
That is to approach the tribunal. That is what learned single judge has ordered.
Yes, my lord.
To go to the tribunal.
That is true, but if the notices go, my lord, appeal is admitted, the notice may go, then the petitioner will get the relief as.
Notice your writ petition has been dismissed. Supposing we dismiss your writ appeal, your remedy before the tribunal will also go.
Yes, my lord, that is.
Then why take that risk? Or if you want, we'll pass the order.
Then I may be withdraw this appeal and then I may be allowed to withdraw this appeal and file a fresh
That file of fresh where?
tribunal
So
before.
that liberty has already been given.
Yes, my lord.
So you pursue that remedy to tribunal and council. MS A. Buzar Barwa, representing the writ appellant, submits that as the Leonard single bench, while dismissing the writ petition, disposing of the writ petition of the petitioner, has given liberty to approach the education tribunal for redressal of grievances, our client would be better advised to avail the said remedy. However, she prays that an observation may be made that any of the findings recorded in the order passed by the single bench shall not prejudice the outcome of the claim filed by the appellant, if any, before the tribunal. To this submission, the net counsel, MS R. Bora, representing the respondents, has no objection. Thus, leaving the petitioner appellant at liberty to approach the educational tribunal in terms of the liberty given by the learned single bench, it is hereby directed that if the appellant approaches the tribunal and files the requisite claim application, the same will be considered and decided on merits without being prejudiced by any of the observations made in the order passed by the learned single bench. With the above observations, the writ appeal is disposed of as withdrawn.
Item number 19.
Yes, please.
Back to your lordship. My lord, in terms of this honorable court order, I have the copy to the CGSC lordship. And today is a matter for admission lordship. I only challenge the page 50 lordship about the notification, which is a complete violation of Architect Act section 45 lordship.
Where is Mr. Chaudhary? Copy has been served on him.
Actually, maybe admit to lordship and I'll inform the Mr. Chaudhary.
You will inform them. You need the matter, require the matter to be taken up today.
Lordship. Lordship, please, yes, lordship.
Password for timing.
Item number 20.
So this is an appeal against the order dated 21/4/2023, passed in WBC note 79 of 2017, my lord.
Yes.
Yeah, my lord, the appellant participated in the recruitment process and select list was published in the year 2007. In first select list, Lord, the appellant stood at serial number 3. Subsequent select list was prepared, where she stood at 4. On the basis of the subsequent select list, appointments were made and 3 persons were appointed. Out of those, 1 did not join. As I was in 4 position, my name was forwarded by the Inspector of Schools. It was forwarded by the Director of Secondary Education to the Commissioner and Secretary Education. But my appointment was not considered. On the other hand, my lord, another similarly situated person.
Sir, the writ was filed in 2017.
That
selection was made in 2005.
That aspect is there, my lord. The delay
There
part
is
is
no
there.
question, no question.
But
Latches.
After that also, my lord, in 2010, 1 similarly situated person
Principle
was
of
appointed.
negative equality.
But negative equality, that question, but on the other hand, my lord, the unreasonable classification on the basis of
Nothing,
which
there
I
is
was
no
deprived.
classification. One who sleeps is not entitled to any relief. Dismissed. Dismissed.
Obviously.
Item 21.
This is that one. Yes.
Please, Your Lordship. My lord, the matter pertains to, my lord, compensation of Zirat, my lord. The property which are standing over the land, my lord. The land was, my lord, the government land, my lord. Some persons who were, my lord, acquiring the land and, my lord, living on that place, my lord, from 100 years, my lord. Thereafter, land was, my lord, taken by the government for construction of new busy railway line, my lord, from, my lord, Sonapur area. And thereafter, my lord, the crops, trees, houses standing over the land were assessed, my lord.
Put the question, respondents. Yes.
And my lord, the petitioner are, my lord, paying for only the Zirat value, my lord, not the value of the land, my lord.
Land acquisition at here.
That is the limited prayer, my lord.
No. Land acquisition.
Zirat. That is only the limited prayer, my lord. And this
That
is,
is
my
it.
lord, identical matter. Numbers of writ petition already disposed of by this honorable court. And my lord, the government, my lord, disbursed the, my lord,
Not
value
this
of the
one.
Zirat to the other.
LARR Weapon Act.
No,
This is
2013.
2013 Act. Hmm.
Earlier, my
Yeah,
lord, it was,
compensation.
my lord, 1894 Act, old Act, my lord. Under that Act, my lord, this was, my lord, happened.
This is,
Now the
this process has
2013
taken
Act
place
in force,
under
my
the 1894 Act.
Yes,
Acquisition was made with,
Yes,
in which year?
It was, my lord, 2010, my lord.
So of course, then it will be governed by this act.
Yes, my lord. Under the old Act,
Section,
1894. My lord,
No, no.
section, my lord, kindly come to section 4.
hmm,
4 of the Land Acquisition Act, my lord, 1894.
hmm.
What is saying, my lord? Publication of preliminary notification and powers of officers thereon. My lord, whenever it appears to the appropriate government that land in any locality is needed or is likely to be needed for any public purpose, or for a company, a notification to that effect shall be
Occupied there.
published in the official gazette and in 2 daily newspapers circulating in that
Definition.
locality, which at least one shall be in the regional language, and collector shall cause public notice of the substance of such notification to be given at convenient places in the state locality.
You're right. We can just answer the appearance. Saying that we be the person interested, definitely person who is holding position or who is an occupation of the land would be covered. Short answer can be given. So that is the answer. to the appearance.
I think there is some relevance of section 9 also.
Let's see. Notice to person interested. Hmm.
Then 9 and 3.
Hmm.
Occupier.
Occupier.
You read in that way.
Yes.
No, it is said that.
It should be the owner.
Enforcers should not be.
Yes.
Will not have
Occupier for decades, they have constructed their houses there. That's right, that is it.
One is landing revenue regulation and 80 only governs the eviction. Person is not evicted. Land is not to be evicted. According to my view, that they will be evicted. In a court, the person is not evicted.
Ah. Puche.
State.
Railways.
With regard to the common order he is referring, my lord, I got some other orders where it is, which has been stated, my lord, it's a government.
Issue is whether a person occupying a government land
Yes,
is
yes.
entitled for GRAR. They
Yes.
are not seeking for compensation,
Not for land.
not for land. That is the issue. See section 3A definition.
Yes, yes.
Land. Of 1894 Act.
Preliminary survey.
3B, if I go to the 3B, my lord.
Hmm.
No, before that you come to 3A.
Expression land includes benefit to areas out of the land and the things attached to the art or permanently fastened to anything attached to the art. Yeah, that is there, my lord.
And 3B.
3B is regard to, my lord, the expression person interested include all person claiming an interest in compensation to may not account of the acquisition of the land under this act. And a person shall be deemed to be interested in land if his interest in an easement affecting the land, my lord.
Not only is been interested includes inclusive definition.
Well, can it be taken after some time? I'll also have to go through my.
Easement affecting the land. That would cover.
Sometime.
All right. When do you want?
It is 2 weeks, man.
And council representing the respondents. Pray for an granted 2 week. And this court single bench has taken the view, number of cases. What's the reference is there. So you just
let me
have to address the court on the point of reference.
Let me go through once more.
2 weeks time.
Obligement.
List of 2 weeks.
Item 22,
That is your lordship. Lordship, this appeal is preferred against an order passed by the learned single judge in the Isol bench.
There is an affidavit which Ms.
Yes,
Kalita has
lordship,
just,
I have received it.
you have received it?
I would, lordship, pray for the matter being taken up on Monday if it is not inconvenient. Lordship. Let me take the instructions on this.
All right. Affidavit on behalf of State of Mizoram has been filed today and is taken on record. The Deputy SGI, Mr. Chaudhary, praised for and is granted short opportunity to go through the affidavit and address the court with the reference to the contents thereof. List on Monday.
My lord, instead of Monday, could it be Wednesday, my lord? Monday have some.
Wednesday.
Yes,
Third,
Wednesday, my lord.
7th June.
item 23,
Wait, please. My lord, this PI list, my lord, regarding the conversion of land, my lord, from government land into private land, in league with the authorities of Karbi Anglong authorities, my lord. So now, my lord, the National Highway 29, my lord, that was, my lord, bifurcated by the National NSIDCL into packages, package wise, my lord.
Yes.
And there was a notification to that effect. Page 33 onwards is the notification first issued on 13/11/2020. Then thereafter, my lord, another notification for these packages, page 57. That is a notification dated 13/3/12/2020. And thereafter again, my lord, notification of 12 July 2021. The roads have been, my lord, land has been acquired for the purpose of National Highway 29 widening and four-laning, my lord. Now, pursuant to this, what happened, my lord, I have stated, my lord, most of the land, my lord, as per the paragraph 19, my lord, page 20, para 19, page 19, most of the land, my lord, which have been, my lord, they have shown to be acquired. These are, my lord, the land, my lord, where no, actually, the no patta is there, my lord. Then what happened, my lord, the government land, my lord, they have been, my lord, converted by the revenue authorities into, my lord, the pattas. And
Just before the acquisition.
yes, before acquisition, my lord.
How long before the acquisition?
My lord,
What is the time gap between the conversion and the acquisition?
time gap, my lord, it is very, my lord, short, my lord.
Have you demonstrated anywhere?
Yes, my, if I.
What is the pleading? Let us know.
Paragraph 19, may I read it, my lord? Then it will be clear, my lord.
Para 19?
Yes, page 19. That the petitioner states that several crores of money meant for four-laning fund had been misappropriated by the respondent authorities of KAAC in the name of acquisition in reference to the schedule annexed to the notification mentioned above. For instance, agriculture land under survey number so and so is nowhere actually found in the name of beneficiary.
All of these. Yes, carry on.
My lord, third line, para 19. Four laning fund have been misapproved by the respondent authority KAAC in the name of acquisition in reference to the schedule annexed to the notification mentioned above. For instance, agricultural land under survey number 122 PP 94 is nowhere found actually in the name of the beneficiary C. Dorsing so and so. And there is no such type of land under his ownership.
What is the response to this para?
To respond to this para, my lord, they have annexed one chart, my lord, showing they have admitted that amount has been paid to that respondent 9, who says that he has land in that area. Who says that he has a land, my lord? Earlier it was government land. He said it was subsequently converted into periodic within the time when the acquisition and survey is going on, my lord. Now, to that, my lord.
Notification district, there cannot be any.
They can't be transfer that.
And that,
Must
my
be
lord,
just before that, some information.
if your lordship will come to,
Converted into commercial just before the. Yes.
there is two affidavit, my lord, if your lordship, in their affidavit of respondent number 6, my lord, who is the competent authority, joint secretary and competent.
Page.
Your lordship will see of their affidavit, page 123, respondent 6, dated 19/9.
Yes, we have that. Yes.
Yes.
Respondent number 6, yes.
Yes, madam. Just a moment. In my, it is different. Respondent number 6, my lord, page, internal page 141.
141.
It should be,
There's some.
yes, my lord, paragraph 36, my lord. Page, in my, it is 145, my lord. Paragraph 36. Yes. Here, my lord, what happened, my lord? May I read it, my lord? That in regard to statement made in paragraph 16 of the petition, the deponent begged to state that the declaration made by Balison Rongpi about non-receive of compensation for acquiring dark number so and so of village Tarabasa, the deponent begged to state that under Fuloni Circle, there are 3 villages, namely number 1 Tarabasa, number 2 Tarabasa, and Upper Tarabasa, dark number 519 of village. Next page, Upper Tarabasa is acquired. But in the 3A notification, the periodic patta number was wrongly mentioned. Kindly see, my lord. That is the anomalies they have committed and admitted. Wrongly mentioned as periodic patta number 50, my lord. Periodic patta number had already been corrected. My lord, during pendency of this PIL, how they can, my lord, do it, my lord? As PP number 82 and send it to the NSIDCL authority for publication in the 3D notification, and the notification under 3D has already been published, correcting the periodic patta of the petitioner as periodic patta number 82. Now your lordship will come to subpara in regard to declaration made by Bura Singh Hamse of village number so and so. The deponent begs to state the declarant has not stated anything about dark number so and so, which are acquired for widening of NS 29. As such, deponent is not in a position to verify the claim. Next, subpara, my lord, in regard to declaration made by Pradeep Basumatari about acquisition of land of dark number 526 of Fuloni Bazar, and the declaration made by Robita Basumatari about acquisition of land of dark number 635 of village Fuloni Bazar. The deponent begs to state that both dark numbers mentioned by declarant are not acquired for widening of 29 NS 29. The land of dark number so and so are not under the land acquisition plan made.
They deny that.
But
these
I
lands
have annexed, my lord, all the documents in my reply. In fact, I have obtained through, my lord, the person obtained through certified copy from the council. The land is there, patta is there, the photograph is there, even the trace map is there. Now, how this is done, my lord? Now, after this, my lord, if your lordship will come to next paragraph number 39, that is also very, my lord, surprising, my lord. Paragraph number 39. That is in regard to respondent 9, my lord.
Yes.
That in regard to the statement made in paragraph 19 of the petition,
The deponent beg to state the land covered by DAG number 122, periodic patta number 94 of village Udarjan C under Fuloni Revenue Circle is recorded in the name of Dorsing Ronghang. Land covered by DAG number 560, periodic patta number so and so of village number 2, Karkok, is recorded in the name of Shiv Mandir. Well, it's a temple actually, government land, malo. Shiv Mandir and Hanuman Mandir is a government land, but they say it's a residential land. They say, my lord, in their affidavit that is a residential land. And a temple, my lord, is not a private temple. If it's a public temple, then it's a land reserved for.
DT land, otherwise also land is of the DT.
Yes.
It can't be a private land.
Yes, but there, my lord, that is one instant, my lord, it was, they have annexed the Jama Mandi showing that it's a
Private land.
private land. Compensation also they admit has been released to that person, my lord, the beneficiary.
But if the Jamabandi is there, then
That is what, my lord, they have created the Jama Mandi.
Jamabandi when? The entry was made when?
Yes, yes.
That is the question.
Yes. Yes. Now, in that respect, your lordship will kindly come to the affidavit of another, the respondent 6 file another affidavit on 26/4/2023.
Annual patta converted, so a little dorsing.
Page 274.
Yes.
And convert annual patta 70 is convert to.
My lord, till now, my lord, that principal secretary has not done anything, my lord. Despite this, he is the superior authority, my lord. Okay, he has not done any inquiry. Had he given any scope and have taken the materials by.
We have made that observation in another matter, or this one. We had made an observation that whether there is any system of audit of all these projects, these councils,
Yes, lordship, that is in another road. project.
another road matter.
Yes, yes. Same thing, my lord, here, my lord, in Karbi Anglong, my lord.
Yes.
Page 274, if your lordship will see, the another affidavit of respondent number 6, page 274, my lord. Page 277, they have enclosed one chart, my lord. If your lordship will see, the chart 280 is start from annexure R1, page 280.
Yes.
The village number 1, Borbukhuri. They say it's a residential land. The name of the landowner is the school, my lord, LP school. Although it was a government land, my lord. And there's
Government land?
Yes, well.
How do you say?
That is the, my lord, the village authority, my lord. I have annexed the villagers also stated, my lord.
No, but as council, you want us to believe that this is a government land, then you have to satisfy us.
Yes, well.
From what material?
Now your lordship will kindly come to page 281, serial number 538, my lord. That is private respondent number 9, my lord.
Yes.
He says that he has land, DAG number 122, agricultural land, section 3, Dorsing, Rahang, compensation amount paid. I'll show a lordship document. And next page, 282.
Same.
Yes.
Dorsing Rongang.
Dorsing Rahang. Then another, my lord, at serial number 25 below.
Shiv Mandir.
Yes.
Yes.
Shiv Mandir, my lord, that is a government land. Now, after this, my lord, they have annexed one Java Mandi, my lord. Now, one more, my lord, page 285. 285, your lordship will see Bhalukjan, block 1. That is serial number 32. It is shown to be KSA Dengao. That KSA is Karbi Student Organization. They say they possess a land. But this compensation was paid to them. The next page, if your lordship see, they to swindle the amount, twice they have included, twice. 286, serial number 33, my lord. That is the, my lord, KSA Dengao. Again, it was smaller.
Yeah, but there are different chunks of land. The area is different.
That is the whole, my lord, the whole, my lord, what they have done, my lord. Now your lordship will see page 287. That is the respondent 9, Java Mandi, my lord. He says that, my lord, if your lordship will see the 288 is the Xerox copy. Patta number 94, Dorsing Rahang. And it was issued
under the signature of which authority we do not know, recently, my lord. 24/2023.
No, that may be the issuance of certified copy.
Now, next date also your
But
lordship.
we don't know what the date of the mutation is.
Now, I'll show my lord that there is one affidavit where my lord, he himself declared that he doesn't have any land, my lord. That affidavit, I will come to your lordship, will come to page 169, my lord. Page 169 of my affidavit, my lord, dated 29/2022.
169.
169, my lord. Additional affidavit. In there, my lord. Page 171, my lord. Paragraph 4, my lord.
Yes.
Paragraph 4, may I read it, my lord? That the petitioner states that in para 19 of the PILs, the petitioner stated that the agricultural land under survey number 122 PP 94 is nowhere found actually in the name of the beneficiary Dorsing so and so. And there is no such type of land under his ownership. Similarly, in agricultural land under survey number so and so is nowhere found in the aforesaid name of beneficiary on the stress of land acquired for building, widening, four-laning, etc. for operation of NS 29. As regards survey number 560 PP 323, the government land was converted to private land, and the name of the landowner is specified in the schedule to the notification dated 12 July 21 as Shiv Mandir and Hanuman Mandir, Dorsing Rahang. And number 2 is Jagdish Verma, which are influential person of the district. Wherein in some cases, government land is shown to be private land of government ME school, and in some other cases, responsibility of KWC. Now, my lord, your lordship will see annexure O, my lord, page 179. That is filed by the villagers, my lord. They declare that, my lord, do we ever declare to the best of our knowledge, and we see that Sri Dorsing Rohang, resident of so and so, one of the beneficiary has no ownership of land in section 3 at Udarjan, but his name was included in the 3D notification for receiving compensation published by so and so. This was done in 29/2020. Now these are all joint signatures. Now your lordship will come to the vital document, page 181. There was a affidavit. Affidavit, my lord, is a form, mandatorily declaration he has made. And in that declaration, your lordship will find that he declares at page 186 that he has only one plot of land covered by DAG number PP 34 and DAG number 170, my lord. At the very, my lord, the first one, my lord. Agricultural land, he has, my lord, only one plot of land covered by PP number 34, DAG number 170. Now, my lord, this was done, my lord, this document was signed on 11/3/21, prior to the NS 28/29 notification. Now, after that, my lord, he doesn't have that land. Now that two land, my lord, that he has received compensation, my lord. Apparently, my lord, it was, my lord, conversion from government land to residential land, my lord. And here, my lord, principal secretary has a role, my lord, to some extent, my lord. And that principal secretary is silent, my lord.
He has not filed an affidavit.
He has not filed affidavit, my lord. He has filed on behalf of Karbi Anglong. But the thing is, my lord, no inquiry, nothing has been done till now, my lord.
Yes.
Petition.
How does a man who doesn't have those lands in 21 gets a conversion done?
My lord, lordship may
What
look
is the
into-
date of mutation? Will you let us know?
My lord, that record is not with me at this present. My lord, I'll produce the record when the land
What
was.
is the report?
But my lord, before that, my lord,
Lordship, the petitioner alleged about the 36 beneficiaries, they are not in existence. If your Lordship look into Annexa, out on page
Why
280,
shouldn't we direct a SIT probe into this? Tell us.
my lord, before that,
This by itself is sufficient.
my lord, all the lands, my lord, the petitioner alleged that we have stated that these are the government land, compensation was not paid.
What about 185, sir?
My lord, page
The
2,
man says, I have got one agricultural land in 21.
my lord,
That's the declaration.
my lord.
How suddenly
My
two
lord,
government
that is
lands?
his declaration when he filed the nomination paper in the under the representation of people.
There's a date 11/9/21.
My lord, he has filed out at
When
the,
did he acquire those other two lands?
my lord, lands were acquired, my lord. We have filed in our affidavit, we have
Let
stated,
us
my
see,
lord,
let us see.
page 124, my lord,
Yes. 124.
124, my lord.
What is the date of the notification, please?
Section 3 notification, my lord, that is 29/7/2021,
Yes, 27, 29/7/21.
29/7/2021.
And this
Section
declaration, just hold on. This declaration, which was read out just now,
My
what is
lord.
the date of that declaration? 11/3/21. Now you point out, where is that,
My lord, that land was not, were not acquired, my lord. That declaration made by the private respondent, that land was not acquired, my lord.
we know, that's not the point. Where are his title documents regarding this two chunks for which he has received the compensation?
My lord, regarding that, my lord, we have received a certified copy of the land records, my lord. But on the certified copy of the land records, there it is that in the Jamabandi, his name is recorded, my lord.
What is the date? And how did he come to own those chunks of land? What is the mode of transfer?
My lord, on that basis, my lord, assistant settlement officer will file the, my lord, on what date, my lord, lands were
Keep
mutated.
your
my lord.
officer present with the record.
My lord.
Wednesday.
My lord.
Council declaration. Keep the land record officer concerned present in the court with the record pertaining to the two plots of land for which the respondent number 6 has been awarded compensation.
Respondent number 9.
Respondent number 9.
Respondent 9.
List on
After we. On 7, my lord.
7th June. 7th June, yes.
All right.
24.
Item 24.
May please, your lordship. Lordship, original records were called for on the last occasion. Original records was.
Original records.
Yes.
What is the matter? Knock-knee.
Knock-knee, lordship.
Yes.
Whether that review medical board has considered the opinion of the civil doctor or not while conducting the knock-knee examination, lordship.
Yes, please. Review medical board. You flagged the documents? Gentlemen, have you flagged the document, please?
Well, I will get it flagged once again.
Get it flagged and indicate on the flag what is the detail of the document. What was the issue? Please point from your documents.
Lordship, detailed medical examination was done at page 62, lordship.
62.
Yes, lordship. It was found unfit for 3 reasons.
Just
Defective
hold on.
color vision.
Just one
Yes,
moment, 62. Yes.
Yes, and 3 reasons are there, lordship. He was found unfit for 3 reasons. Defective color vision, compact earwax and knock-knee.
Then review.
Then, lordship, the
Appeal.
P62, serial number 2, lordship, he was directed to file an appeal
Yes.
after obtaining a medical certificate from a specialist doctor.
Yes.
Then that certificate is at page 63. There were 3 specialists that was issued by Senior Medical and Health Officer, ENT Specialist, Difu Civil Hospital, Registrar, Department of Orthopedics, Difu College, Difu Medical College and Hospital, and
Okay.
ophthalmology. So there were
Yes.
3 specialists which says that I'm fit for the post. And there was no such knock-knee as in the detailed medical.
But they don't give any details, no measurement.
Lordship.
There is no measurement in this report.
No, that
What is
not-
the distance in the two knees? They have not mentioned. Then now you file an appeal.
Yes.
What is your case?
In the review medical examination, Lordship, that opinion at page 63.
Yes,
That has not been considered because. the
this
guidelines-
report has not been considered.
Yes, because the guidelines says, the guidelines.
That was considered, my lord,
How do you say so?
and the authorities have again came to the conclusion that the gap between the two knees was more than 5 centimeters.
Where is that consideration? Let us know.
My lord, page 298.
298,
Flag X, my lord,
flag H,
X.
X. Conduct of review medical exam.
Lord, gross knock knee was the conclusion.
No, understood. What about the report which he has produced? That is required to be considered.
My lord, there is no specific mention of that, but the records of the civil hospital which was produced, that was there in the record. The authorities have.
Show this picture to the council.
Yes, my lord, that picture was before the learned single judge, my lord.
See this picture, photograph of your client. Man may lie, circumstances do not.
This is just a visual impression. Lordship.
Oh, gentlemen,
Prima
don't
facie,
tell us,
my lord.
don't tell us.
Prima facie, it's a visual impression, but
So what more is wanted?
Lordship, because the guidelines say so that when review medical is done,
Hmm.
X-ray has to be done in case of knock knee, if he is found effective for knock knee.
Where is that? Let us
At
see.
page 170, Lordship.
170.
Clause 3HI, Lordship.
Yes, guidelines.
For knock knee, bow leg, cubitus
Just-
valgus, and
just
varus
a moment.
deformities. X-ray plate with findings should be attached.
Yes. What about this?
No, the X-ray was not done.
Then
X-ray
all right,
has been done, Lordship.
get a fresh review medical examination. We'll keep it pending. We'll direct you.
My lord.
Or we'll dispose it of, saying that get a fresh review medical examination conducted in light of the
My
guidelines.
lord. My lord.
Then counsel, the petitioner has, the writ appellant has challenged the decision of the respondents in rejecting his candidature for selection in the selection as constable
Yes, Lordship.
in so and so by declaring him to be unfit on the ground of gross knock knee. First of all, the petitioner has challenged the review medical examination report on the ground that the same was, that the review medical board did not follow the guidelines, prevailing guidelines for review medical examination, to be specific regarding the clause 3I thereof, which prescribes that for knock knee, bow leg, cubitus valgus, and varus deformities, X-ray plate with findings should be attached. It is not disputed by the respondents, and it is also not borne out from the record, original record presented for the perusal of the court, that the review medical board undertook the X-ray examination of the appellant. In this background, the respondents are directed to get conducted a fresh review medical examination report of the petitioner appellant within the next 2 weeks by adherence to the guidelines prevailing.
On the internet and all from that hospital.
The observations after conducting the review medical board, the authorities shall take an objective decision regarding the candidature of the appellant in the subject recruitment process without being influenced by any of the observations made in the impugn order dated so and so. With the above observations and directions, the writ appeal is disposed of.
Appraised, Lordship.
Item 25.
I'd seen it first when that was taken. अभी ध्यान नहीं था उनके language से Yes, yes, yes. Return the original card.
My lord, the matter may be fixed up for final hearing, my lord.
So ऊपर ही लिख देना. Listen, mention at the top of that order. Original record has been produced by so and so.
Right, please, your lordship, my lord.
Yes.
My lord, in this case, my lord, tender notice was circulated for the year 2023 for settlement of various hard-battered markets. For settlement of various government
Markets.
Yes, my market, hard the fisheries, my lord. In that case, a particular clause was incorporated, that is clause 10.
Yes.
Which says, my lord, the bid offered by the highest bidder will be accepted for settlement. Even if it is found that he has not submitted other necessary documents as per terms and conditions of the deed, except court fee and earnest money.
So for the respondents, money matters.
Yes.
Yes.
And he will be given 3 days time. If he emerges the highest bid, he
Highest
will be
bidder.
given 3 days time, my lord.
To remove the
submit
anomalies.
requisite documents, my lord.
Yes.
If fails, my lord, then it quotation will be rejected, my lord.
Then
The same issue has already been dealt with by the coordinators of this honorable court in WPC number 27/2022 and 45. In that case, my lord, the coordinators of this honorable court says, my lord, if the clause 10 is made applicable, it would be prima facie violation of the principle of equality as enshrined under 14 of the Constitution, and it would be against the sanctity of the bidding process, which require fairness and transparency. That judgment will be placed, my lord, 17/5/2022. That judgment is still holding the field.
you really rectify things. Just let us see the reasoning of learned single bench in this judgment.
My lord, there's not a judgment is under challenge, my lord. That is page. Learned single bench says, learned my lord, single bench says, my lord.
Yes.
So far such clause is concerned, this clause is of the considered opinion that, my lord.
Yes.
There you also find page, we start from page 104.
Para.
Para 23, my lord. On the same issue, the two contrary judgment before the honorable court. One says, my lord, it is against the principle of equality, but this present judgment, which is before in this appeal, it says no. It is in accordance with the principle of equality, in accordance with the fairness and transparency of the bidding process. The two contrary view in the same issue, my lord. Against that judgment, my lord, the honorable signature appeal was filed. The 204/2022.
Yes.
That appeal was withdrawn on 16/2/2022.
Withdrawal would not make that judgment a binding law.
But this judgment rendered by earlier, that is still holding the field.
Yes.
In other way, my lord, it can be interpreted, my lord, the clause 10, my lord. The bidder at the time of submission of the sealed bid in response to tender notice, he need not submit any other requisite documents except court fee and earnest money.
Then you participated in the tender without challenging that condition. What prevented you from challenging the condition before participating?
I was prejudiced, my lord. When my lord, I was prejudiced because, my lord, in the year 22/23, my lord, market was settled in my favor as being emerged as the highest valid bid. Then what happened, my lord? One tenderer who offered highest bid, but his tender was rejected due to non-fulfillment of the
conditions.
terms and condition, my lord. Then he approached the honorable court.
Yes.
Initial under single was interperson stay order, but in preferred an appeal, in that appeal, stay was granted. So despite being my lord, highest valid bid, I had the opportunity to run the market only for 2 weeks. Then finally on 17/5/2022, the judgment rendered by Lana single judge saying that if the clause is made applicable, it would be against the principle of equality and fairness transparency of the bidding process. Thereafter, my lord, I got an opportunity to run the market, my lord. Then again, my lord, the writ petition went in a subsequent financial way. Yeah, when the same clause is incorporated in the need, then we filed a writ petition, challenging the same clause, my lord. The writ petition, along with other similar, came up for hearing in 2311, my lord. Then we also brought.
I think
Brother Manish is right. There's a reasonable look at, but the issue is. The condition of having participated in the tender, you can't turn around and say that now the condition distribute. Yeah, this is challenge before participating. You satisfy us that after participating in the process, you can challenge the condition. Any law to that effect?
Yes, I have participated.
Then once having participated without challenging that condition.
My lord, my lord, has to submit, my lord. If this clause is made applicable, it will favor those standards who
offer the highest money. State is concerned with revenue.
Well, at least, my lord, then what the use of, my lord, putting terms and conditions in the need, my lord, is asking question myself. Then what is the use of?
So then you should have come with a challenge before participating. Why not then? What prevented you? The condition was existing. You knew it very well. You took your chance. You participated. Your bid was not on the same at par with the bid of the successful bidder.
Before my rendering this opinion, my lord, prior to that, the coordinators of this honorable court already rendered opinion that inclusive of the clause 10, or if it is made applicable, it is violation of the principle of equality, need against the fair transparency.
When was that challenge laid? Tell us. Whether before participating or after participating. In that writ, 45/22. When was the writ filed? Let us see.
That was it filed by the bidder, my lord, then after participating.
Let's see. Read the order. After participating, not after settlement.
My lord, 129, my lord.
We are on that.
Yes, my lord. Wherein my lord, I had been arraigned respondent, my lord, settlement holder. In that.
In that writ, you were this respondent.
Respondent.
Yes.
It is 45, my lord. In my lord, that was 27 of 2022. That I was with NX, my lord. In that case, my lord, our respondent number 8, my lord, settlement holder. That was prepared by Rafiqul Islam on the same day, on 17/5, my lord. My lord, what is the my lord, para 3? Para 3 of the judgment, my lord, you also find the same thing, my lord. Para 3. Agreed by the order of settlement issued in favor of respondent number 8. And I was also respondent number 8, my lord. The petitioner has approached this court by this petition challenging the same on the ground internally that market has been settled in favor of respondent number 8, despite the petitioner quoting a higher bid value than the respondent number 8 in settling the market. The Zilla Police did not adhere to the condition incorporated in class 10 of the tender notice.
Yes.
My lord, then you also find para 20 of the judgment that for the view taken by a single judge. In the light of discussion made above, it is clearly emerged that clause 10 is a standalone provision, para 20, my lord, of the judgment. And the procedure prescribed therein is incompatible to the other terms and conditions incorporated in the tender notice, clause 17. And this particular clause.
Just hold on. Whether this judgment was put to challenge?
Yes, that was challenged by my lord.
And the writ was appeal was withdrawn.
Appeal was withdrawn on 16 to 2023, my lord. You also passed order, my lord. I was responding in that case, my lord. On 16 to that was withdrawn.
We'll have to admit the petition appeal then. Admit. The respondents are duly represented. Thus, notice need not be issued. List for final disposal.
Your Lordship, before going to the merit of this appeal, Your Lordship, you kindly see from the comparative statement, it appears that he is the 13th highest bidder. In the serial number, his name appeared in the number.
This is not a PIL, gentlemen.
No, my lord,
If you are the 13th higher bidder, how are you aggrieved? Assuming that his bid falls.
My lord, I am not saying that my lord, surrender mark is in my favor, my lord.
Then
I'm not saying that was the best made vote on a single judge. I said whoever come out.
then why we are required to adjudicate this matter?
I have very deep.
Gentlemen, assuming that the bid of the successful bidder is interfered, you would not get the settlement because
If I emerge the highest valid bid, my lord, that is my case. Though I am placed at the number 13.
yes.
If those who are tender are was placed above me, if they are found to be defective, my lord.
Oh, ifs and buts.
They
My
will
lord,
not get even.
no, that is not my case.
They are parties in between the successful bidder to you, the 12 other bidders.
No.
Are they party
No,
in
no,
this?
my lord, if the first bidder, when offer is made to the first bidder, when he fails, then offer comes to second bidder.
Then
Then third and fourth, my lord.
those persons are not party in this appeal.
No, my lord.
Then
My-
what relief can be given to you?
No, my lord, I am.
His bid be cancelled, examine the bid of the next higher bidder.
Yes, my lord.
What happens? You are nowhere in picture.
My lord, that is my case, my lord. There must-
No. Have you made an averment that the bids of all 12 bidders above you are defective? Is that an averment in this?
No, my case was there, my lord.
No.
Each
Then
and
you
every court-
are required to change the condition.
Paragraph 19 of
Did you
the.
participate in this process or you before participating challenge this?
No,
Participated.
I participated.
Then select.
I participated, my lord.
Dismissed. 13th bidder coming.
Obliged.
Item 26.
My case was not, I am 13 or 14. My case is there.
This is not a PIL, sir.
Here, man, I'm praying for some time to file a response, my lord.
Land council, Mr. Place for is granted. How much time?
2 weeks, my lord.
2 weeks time. File affidavit on that respondent.
Obliged.
Item 28.
Now, in this case, last occasion, they took time to file.
Yes, please.
No, I'm sorry, my lord. We are yet to receive any instruction in this case. Some further time. Actually, my lord, at their instance, my lord, this notice had gone, my lord. Otherwise, the stand is quite clear of the state.
Okay.
We have in 19, my lord, that is at page 186, my lord. They are challenging this. Page 186, my lord.
186.
Yes, please. My lord, this is relating to grants of permanent residential certificate, my lord, to a group of people who are STs in the state of Assam, but not in Arunachal.
STs.
ST.
So what do they want?
My lord, they want PRC there. Now, the government has taken a conscious decision, my lord, in the cabinet, not to issue PRC as of now, my lord. And they have come against that decision.
So they want to carry their caste into that state of.
Yes, my lord.
Yes,
This is not the case. Case is that, madam, initially they moved a writ petition. Then direction was given to the government to constitute a higher power committee. Higher power committee, my lords, joint committee submitted a recommendation to issue PRC. Then government issued notification.
Not that much.
First they can't give.
Even same name.
Same name. That's true. Let's see the prayer, please.
That is page 106, my lord.
They are asking for permanent residence
Yes.
certificate, not the caste.
Not the cast.
No, PRC, my lord.
Then what is the difficulty in PRC? What is the stand of the state?
Stand of the state is, my lord, as I have, my lord, just placed, my lord.
Page 186.
Yes, my lord, that is, and also at the 215, my lord, that is a gazette notification, same decision. 215 is a gazette notification.
But then you have to justify the stand. You have to justify the stand. This decision is under challenge.
This decision is under check.
Then
Your lordship will kindly allow us some more time.
the council, Mr. Goswami, prays for and is granted further opportunity of
6 weeks.
6 weeks to file affidavit on behalf of the respondent.
Much obliged.
Not for every reason, but there are some young people criteria. Because these are the hormones which want to come in time.
Yes, you're right.
Item 40,
Adjourn हो गया. Fix it too. Okay. Yes.
May it please your lordship.
Yes.
Well, through the writ petition, certain provision of the Boroland University regulation has been assailed. Well, briefly, the facts, the petitioners, there are 16 petitioners before your lordship. They took admission under an UN academy under the Boroland University. There is an act of 2009. In 2017. Now, my lords, they have cleared, it is a semester-wise, 6 semesters biannually. They have cleared all the subjects except one backlog is there. Now, during the COVID period to the virtual mode in 2021, it related to a backlog of the first year. They filled the examination form, paid the examination fees, and appeared before the. This was the 4th attempt. Now, the exams were not declared, so writ petition was moved before your lordship, before the single judge, seeking a declaration to treat it the 4th attempt as valid. There, the authorities, the university has taken a stand that under 5.3 and 19.6 of the regulation, though the maximum period where you can, the span period is 10 semesters, which means 5 years. An attempt to each candidate is only 3 attempts. So this was the 4th attempt. So in these circumstances, we have assailed the clauses because the affidavit before the writ petition said that this comes in their way. Now, my lords, under the UGC, my lord, the UGC Act, because these are all 12, this is the university concern is granted status under 12B, it gets grants. Now, under 12D, it has the power to recommend. And there are consequences which flow if those recommendations are not followed in 14. Now, the UGC had made certain recommendations to all universities. Because there was lack of uniformity so far as the span period was concerned. So a recommendation was made to avoid this lack of uniformity to all colleges. They say that the span period should be normal plus 2. That means a 5-year span is given for you to take the backlog. There is silence so far as the attempt is concerned. Now, the last clause of the university notification says, these are, however, subject to the state rules and regulation. But, your lordship, obviously, those state regulation also has to be in tune with the basic purpose of the notification, because that was brought in because various universities were having their own scheme of things. So to avoid that, so N+2 was put in place. Now, one issue is, my lords, now insofar as this regulation under the Boroland University Act is concerned, it has a maximum period of 5 years, but 5.3 puts a restriction on the number of attempts, which is not found in the university notification.
Right.
Now, this is how the challenge is being laid. One, can it
defeat the various, because you're giving one right that is span period of 5 years. Can you defeat my right within that span period by restricting it to only 3 attempts, which is absent in the UGC notification? Now, state rules also, my lords, which the last provision in the notification says, that also, my lords, the state rules can't be like, it is subject to state rules, but it can't be to defeat the very purpose of it, which I've already
What do the state rules postulate?
postulated. That your lordship will find. It starts, my lords, at 769. Though there is no specific power relating to regulation, but under the act, the university has been invested the power to conduct an examination.
Yes.
And the ancillary powers would be there.
All right.
My lord, that starts at 69.
Yes.
And your lordship would see, first line, this is the university. They also proceed on the basis of University Grants
UGC,
Commission has
UGC,
made.
yes.
What we are concerned is clause 5, my lord. 873, my lord. May I read, my lord? 5.1. The undergraduate degree program for a regular student shall be for a minimum period of 3 years and a maximum period of 5 years from her date of admission. Each academic year shall comprise of 2 semesters, that namely odd and even semesters. Odd semesters 1, 3, and 5 shall be from July to December, and the even semesters 2, 4, and 6 shall be from January to June. There shall be in each semester not less than 90 actual teaching days. A regular candidate shall have to undergo the prescribed courses of studies in a college affiliated to the Bodoland University for a period not less than 3 academic years and not more than 5 academic years. So 5 years is also contemplated here, in which he will have to
Is the
accumulate.
UGC not intending to file anything?
My lord.
No, UGC doesn't want to file affidavit. We'll file when? He's already argued for 10 minutes. But if it is to be adjourned for that reason, why unnecessary waste the time of the court, sir? UGC's affidavit is this.
That would be relevant.
UGC's affidavit is
My
this.
lord, my lord.
You could have said so before. Okay.
My lord says the pleadings are complete. The note also said, my lord, sir, I didn't want.
The affidavit on behalf of the UGC has still not been received, and counsel representing the UGC. Place for it is granted. 10 days time to do the needful. List of 10 days.
Deeply obliged.
Item 21.
With regard to my lord, respondent number 1 and 8, we'll file our response, my lord, on 2 weeks or needed. Instruction received, my lord.
Counsel representing.
Respondent number 3 has already filed.
Respondent number 1. Praise for Mr. Das.
2 weeks, my lord.
Praise for it is granted. 2 weeks time to file affidavit on behalf of
1 and 8.
such respondent.
Compensation.
2 weeks. Supplementary लीजिए ना पहले supplementary.
Supplementary list, item 34.
For the timing, Mr. You can have, you will supposed to argument is in the action.
2 days back. when we pass an order in a preventive petition, like few days back, I don't know the name. This is, when we granted compensation, I think this must be the pending 50,000.
Timing one.
Yes. Okay, so taking note of all relevant laws that the constitutional provisions. Yes,
Item 37.
yes, madam.
Lordship, I pray the matter to be taken up at 2 o'clock, Lordship. It will take another 15-20 minutes to file the affidavit. Lordship.
Is there an order of confirmation?
Yes, Lordship. It was
When?
confirmed on 31st March 23, Lordship.
No, my lord,
It
this
was
is-
March.
Yes,
23?
Lordship.
What is
my
the
lord, this
initial date of detention?
19 May, my lord, government passed the order, my lord, 19 May 2023, my lord.
Where, have you placed it on record?
My lord, my learned friend submitted one affidavit, my lord, to me.
When?
Lordship,
Today, my lord.
today, Lordship, it will take another 15-20
Yes, yes.
minutes, Lordship.
Let us see the order. Let us see the order. Because the detention is of 14th February.
14
It had to
February.
be confirmed by 14th May.
Lordship, Lordship.
So 19th May order is gone.
Advisory board, they have, advisory board opinion was on 31st March 20.
Now what took you 2 months to confirm the order?
Lordship, thereafter he represented Lordship.
Madam, there is a mandate of 22/5.
Lordship.
Even a day, minute beyond 3 months. You can't keep a man behind bars.
Lordship, can you take up the matter at 2 o'clock,
Yes,
Lordship?
can you save it by 2?
Lordship,
Are you sure? Read the judgment.
Lordship.
We have awarded compensation. Now we'll direct that
Lordship.
the recovery will be made from the secretary.
Lordship.
Read the judgment. Idena inko vapas. Give it to her. Your officers, they are incompetent, absolutely. And this order probably came out because we had given that direction. Otherwise, your officers would not have even thought of it. Come at 2, sir.
Lordship.
Yes.
Pass over item 19.
Keep your secretary online. At 2, keep your secretary online. He should join through VC. Secretary or commissioner, who is the authority? Madam, who is the detaining authority?
Secretary, Lordship, of Home and Political Department, Lordship.
Keep the secretary online. At 2.
Sorry, I could not present while the matter was called up. For the 2 weeks time is required, time
For
the I would say the central government for the respondent.
what do you want? Why? To do what, sir? For what purpose do you want the time? First time?
No.
The second time, the earlier day.
Mr. Chaudhary was appearing. Today you are appearing.
I'm instructed to appear before I have to communicate with the authority. The required information is not forthcoming. That is why my prayer.
You are not making yourself clear, sir. What should we write in the order? Why we are giving you the time? For what purpose?
To obtain the instruction.
Grand Counsel, Mr. So-and-so puts an appearance on behalf of the respondents. Now, Mr. Chaudhary will not be appearing. He submits that he has now been instructed to appear in this matter on behalf of all the respondents and that he needs 2 weeks time to complete his instructions. Time period for is allowed, list up to 2 weeks. This is item number 19.
Lordship.
Hearing, take up hearing.
Daily list for hearing, item 32.
There was one matter in which Mr. Chaudhary was to appear. 5, 6, 7. What has happened? So we need to wait for him. If the passed over matters are to be called out, they have to be called out. You have not said that it will be taken up at 2. Then call out those matters.
Only. Lordship, in this matter, Lordship, senior counsel, Mr. K. M. Chaudhary is appearing.
This is the second call, sir.
Lordship, he is on legs, Lordship. He is on legs, but I have told. Sir.
That's your problem, sir. Our court master was accommodating you without permission of the court. The matter has been called out second time.
Lordship.
Can it now be adjourned on the ground?
Lordship.
The senior advocate is not here.
Lordship, can it be taken at 2, Lordship?
This is the last time we are granting this accommodation. There is no third time pass over lawfully.
Lordship.
At 2. Yes. Whatever the matters are passed over, they have to be called out. Unless we have given. Affidavit. All right, let that come then.
Lordship, may I make a prayer? Lord?
In which
Can it
item?
be at 3, Lordship, because.
At 3?
Yes, Lordship, because.
If we complete the board, we are supposed to sit here.
Otherwise, Lordship, let me finish, Lordship. Let me finish my part, Lordship.
All right, argue.
Because today we are.
Item number 4, 5, 6.
Yeah, 5, 6, 7, Lord.
5, 6, 7. Yes. You are appearing for
CBI, Lordship.
CBI. What is your argument?
Lordship,
What are these IAs basically?
IAs, Lordship, are almost similar, Lordship. In this IA, Lordship, we have prayed before this honorable to give direction to the state government to accord approval.
Can that be done?
Lordship,
Give us the law on that point.
Lordship, there are several Supreme Court decisions where it
Let's
has
see.
been held, Lordship. Section 6, they are basically.
Let's see one judgment, please.
Lordship.
IA 4165.
1887, Lordship.
1887. 1887. Yes.
Lordship, what PCX section 17A provides is that, Lordship, approval is required to investigate any offense under PC Act, Lordship. Approval is required.
Approval is required.
Lordship.
Read which judgment are you citing? Read Mansukh Lal Vittal Das Chauhan.
No, Lordship, I am citing, Lordship, this State of West Bengal and others versus Committee for Protection of Democratic Tribe, West Bengal, Lordship.
Yes.
That cannot be act as a rider on the direction given by this honorable court, Lordship. This honorable court has already given a direction to investigate.
Inquire. Preliminary inquiry.
And then to proceed.
As per law. So law says for CBI to register an FIR and investigate a case, it has to have the permission.
Right.
As per the DSPO Act,
Right.
Delhi Special Police Act.
Right.
So can the court give that direction to the state to grant consent for investigation? Let's have that law.
Right. Lordship, if we.
And now the situation is even worse under the new amendments, because now you will not register the case for the old PC Act.
Right.
Or will you?
No, Lord.
Then under the new act, even for registration of the case,
Right, Lord.
permission is required. Then give us one judgment on that aspect.
Direct judgment. However, Lordship, if we go through the judgment of this
Yes.
Committee of Protection, Lordship may kindly come to para 13, page 320, page 329.
What is the application? What is the provision under which you have filed the application? Let's see, please. What is the subject matter of your application?
Lordship, I'm sorry.
In the matter of page number 2.
No, Lordship. 69. Para 69, Lordship.
No. Just starting, second page.
IA.
Yes, IA, of course.
An application. 150.
150 on the code of. Yes, Lordship. That is there.
So, do you want to file a plaint or what?
In all the cases, Lordship, I have been entrusted to handle this case effectively, Lordship.
Mm.
In most of the cases, such type of.
It had to be under 482 maybe.
Right, Lord.
226, 151.
Right.
Strange. Anyhow, What is the law you are relying upon?
Also, I've just cited the judgment lordship, para 69 lordship, may kindly be listened. In judgment to 2010.
Para 69.
69 lordship.
Yes.
Judgment to the king.
I'm on 188, sir. WPC. That judgment is there. State of Arunachal versus Detention.
Judgment that has been made.
Preliminary inquiry. Yes.
In fact, my lord, what was directed by this honorable division bench was a preliminary, not an
Yes.
investigation.
Now they are filing an application
Ah.
to register an FIR to investigate.
No, my lord.
What is your stand?
No, what had happened, my lord?
Why do you want to protect the offenders?
No,
What is why the state is hands in glove with the
No, but
offenders?
I'm coming to that. my lord.
Yes.
If your lordship will kindly take this IA 4165 of 20.
No, we are having 1887.
If your lordship would kindly have IA 4165,
Yes.
where all the documents are chronologically there, my lord.
Yes, all right.
Yes,
4165.
yes,
Now, basically, Mr. Chaudhary,
yes,
your role is very limited.
yes.
This is intercept
No,
between
my
the
lord, there was
court
a-
and the CBI
there was a-
because the original petitioner wanted to withdraw the petition. This court refused.
Correct,
And there are observations in the earlier orders whereby PE was directed.
yes,
That observations, if found to be established after PE, then they constitute a cognizable offense. Now the issue only is whether the direction to register the FIR without consent of the state
yes.
is
that's the
permitted
issue.
or not.
My lord,
Yes,
the permission has been denied by the state.
maybe,
Yes,
maybe.
yes.
Yes,
Now, the issue is, my lord,
yes.
there is an order by this honorable court where, my lord, there was a direction issued that in fact they agreed also that the order by learned single judge of this honorable court, my lord, that your lordship will get at the summon order to the board. Yes, page number 66 of that IA, my lord.
Yes.
It starts at page 66 and my lord will kindly come to page 69. Please come to the last subpara, my lord. The petitioners are the person against whom FIR dated 27/6/19 has been lodged by CBI, making certain serious allegation. Mr. Bora, learned counsel for the petitioners, has assailed the procedure adopted by the CBI authority primarily by taking two grounds. Firstly, that FIR ought not to have been shown to have been lodged by the High Court, since division bench has merely issued a direction to CBI to conduct a preliminary inquiry in the matter. Secondly, Mr. Bora submits that in view of the specific direction by this court to proceed in the manner in accordance with law, it was incumbent upon the CPI to obtain approval under section 17A of the amended act of 2018, that is PC Act. According to Bora, CBI authorities were conscious of the legal requirement which fact would stand established from the application filed by CBI,
Prevention of Corruption Act.
which was subsequently withdrawn.
Yes.
My lord will kindly come to page 70, my lord. This is important.
Hold on, sir.
I'm sorry.
Hold on, please.
amendment to nine. Amendment.
This is there, this is Eviction.
It doesn't matter, it's not required. Yes. 17A. CBI, yes, maybe. I can do. No police officer shall conduct any inquiry or investigation in preference in the health. That it will be recognized that the can taken as and the charge of the
Mr. Counsel, not to take some research into the issue that where the public servant is no longer on the post,
Yes, Lord.
these provisions, they are not operative.
Before amendment, consent is, I mean to say, sanction is not required, but after.
Sanction is not required. No, even after amendment. Public servant is or was. That is what the issue is.
Yes.
So they are no longer public servants.
Right.
Why do you need the permission?
They are not.
They are no longer holding the post.
Yes,
So come with the research on that issue.
Section 6 is also there, my lord.
Six, Lordship, I have given a judgment in para.
6 is, there is the answer.
Actually, my lord, Lordship, kindly bear with me for 1 minute, my lord. What had happened?
All
is-
the things will
No,
be
no, no.
changed,
The issues are not very serious, my lord. Some work related to.
Tenders to family members.
No, my lord, some civil construction works were given in respect of KVS. It is not the allegation of anybody that works were not done, but works were done without tender.
Yes.
And my lord, the mandatory nature of tender came only in 2008. Prior to that,
Doesn't
my
matter.
lord, there
So
was.
let it be investigated. Why you're shying away from that? If you say everything is spick and span, let it be investigated. Transparency.
Lordship, earlier, on revision petition.
They'll give a final report. Why are you bothered?
Earlier, Lordship, a revision petition has been filed by accused person that has been dismissed, Lordship.
Revision against what order?
Against the, for quashing of the FIR, Lordship. That has been dismissed. Lordship.
Revision can't be filed for quashing. That has to be a criminal misdemeanor petition. No, you make research on that. That if the public servant no longer holds the post, what kind of permission is required? List on. 6th June. We'll also do some research.
Highly okay.
7. Well, it could have been 7th.
7th.
Instead of 6th.
7th. Then that IA number, the first one also, 4th, item number 4. Don't pass the order. Get it listed on 7th order. Same issue is there.
Deep level.
Highly okay.
35, 36. Take it at 2. Take it at 2. Board is over. Hearing list. Yes. Okay.
This hearing is not going to go on 4/2021.
For hearing, item 32.
But I- is the-
Still good.
My lord,
Obviously.
Because name is.
No, if your name is mentioned, yes.
my lord, Justice Chaudhary may not like to take up.
Let's be for a bench of which honorable justice. Eddie Chaudhary is not a member.
In fact, yesterday, before going to the brief, I asked my junior, find out from the order sheet whether his lordship's name appeared. Then we found on 2 days. On the file today.
Item 33.
Grazing ground.
Made please, your lordship. My lord, in this case, a particular land which has been given to Gaushala in Nagaon district is the subject matter. Now, my lord, when the writ petition was filed, it was filed on the premise that, my lord, before de-reserving the land, Rule 95A mandate was not followed. That is not correct. There was in fact a separation of fact that way, my lord. So, my lord, in fact, by following the due process of law, the land was de-reserved and settled with the. Now, my lord, they are possessing the land for the last from 1971. And I would say, my lord, the writ petition was instituted after about 41 years, my lord. Now, if your lordship would kindly come to page, my lord, 84. That's the decision of the government, my lord. When the capital was in Shillong, not even in Guwahati, my lord. On 11th of September 1970, it appears that DAG number so-and-so, so-and-so, and so-and-so comprise an area of 198 bigha, 1 katha, 81 lechas of land. Out of this, an area of 168 bigha, 1 katha, and 81 lechas seems to be highland. Government, after considering the importance of Gaushala, is pleased to approve settlement of land with the said institution, not exceeding 75 bigha on payment of premium at the rate of 10% of the market value of the land. The remaining areas are kept reserved for future use by the Gaushala. For formal de-reservation proposal may be submitted to the government early. So in principle, my lord, decision was taken. Then my lord will kindly come to page number 85. Now, this is a communication by Deputy Commissioner Nagaon to my lord that organization where they were asked to deposit the, my lord, required requisite premium. You are hereby asked to deposit in the Nagaon Treasury a sum of rupees so-and-so being premium at the
What
rate
is
of
95A basically provision? The compensatory land must be awarded. That's a mandatory requirement.
Yes.
Was it followed?
Let us follow now.
Let's see.
Yes.
Where is the order?
Yes, yes. Then my lord will kindly come to page number 86. Only thing is, my lord, page number 86, my lord.
Yes.
The possession was also delivered on 6/10/70. That is something, my lord, some irregularities there that I will not say no. Now, regarding the moot question, my lord, whether the procedure was followed, that lordship will kindly come to page number 95, capital A. That's the required notice under 95A.
Yes, they in the 7th itself.
Oh, thank you for that. 95A to 33. Sorry, my lord, page 33 is the type copy. Page 33. It is notified for the information of the general public that 75 bighas of land has been proposed to be de-reserved from the part of DAG number so-and-so in majority under Nis Sohor Moza for opening up of a Gaushala. Anyone having objection against opening up of this said land can file objection before my office within 1 month after receipt of this notice. Otherwise, action taken will be taken as per law. Now, after this, my lord, page 95A.
There is a proposal for compensating, sir.
Yes, my lord. Proposal received for. Then my lord will kindly come to page number 99, my lord. This is a document, my lord, which the petitioner annexed in the writ petition, where they, my lord, they did one mischief, my lord. It date should be 5/2/72, not 22/4/71. Now kindly see, my lord, as secretary to the government of Assam so-and-so, in continuation to this office letter dated so-and-so, I have the honor to say that after publication of the notices under Rule 95A of the so-and-so objection petition was received and heard the petitioners locally. The surrounding villagers are vehemently objected to the open the entire reserve, especially in the high portion where cattle usually graze. The portion of 75 bigha of land covered by DAG number so-and-so were allotted for the Gaushala. The people of the majority village has vehemently opposed for this allotment, and the reasons for objections are so-and-so. This portion of the land is required for the purpose of grazing of village cattle. A vizier was formed by relinquishing their own patta land. This is not correct, my lord. Portion of this vizier is used as graveyard that VZR will be required for development of public institutions such as school, etc. During the flood and in the rainy season, this portion is the only highland where cattle population can safely be kept. The objection petition is enclosed herein. As regards the opening of low-lying portion of the VZR, I am to say that this portion of VZR, that is about 40 bighas of the land covered by Doug number so and so, is under cultivation of some influential person of majority village. As stated by them, they cultivate this portion of the land only to utilize the proceeds of the cultivation for development of the institutions of majority village. As such, it is concluded that this portion of 40 bighas of low-lying land was never utilized for the purpose of grazing of cattle, and it was under cultivation since long. So I
Chaudhary,
recommend-
we are asking you, where is the proposal to compensate this loss of grazing land? Where is that proposal?
No, my lord, it's a government land, my lord.
Maybe Kaushala land, grazing land, if de-reserved, then equal portion has to be reserved for Kaushala, for grazing. Where is that proposal?
My lord, under the.
That is what the provision is. That is what the single judge holds.
Yes.
Yes.
Then my lord, final order is at 101.
95A.
95A, yes.
Yes. Read, please.
Yes.
Where is that excise taken? Show from your pleadings that this requirement was
1 second.
complied with. Grazing rules.
Yes. If at any time the deputy commissioner is of the opinion that a village grazing ground constituted under the foregoing rules is wholly or in part not needed for the purpose for which it was
Of course, that
allotted.
opinion has to be formed.
Yes.
Not needed. Is
He
there any
shall
opinion?
publish a notice regarding the
Sir,
proposed.
wait, Mr. Chaudhary.
My
Is there any opinion to this effect in the allotment process, de-reservation process?
No, that, my lord, records will reveal, my lord. I think the government will have to produce that, but as far as there are
The
two
orders have to reflect.
Yeah, no, well, I was reading that order, if your lordship will kindly permit me, at page 99.
Yes.
So, last para, my lord. So I recommend opening of 40 bighas of low-lying land of majority.
So that
VZR
recommendation has been denied.
to settle
You-
the
we
same
are-
with
we
landless.
are- Mr. Chaudhary, that is the second part.
Yes,
We are concerned with 75 bighas, the first part which has been
yes,
approved.
yes. Now,
Now what-
for that, my lord will kindly come to page 100. The
Yes.
last two para. The matter has been considered by me and discreetly inquired into. It appears that only a small group of persons have been objecting to the Gaushala as well as settlement with Konok Soikia and others. I find that plenty of land will still be left for the BZR after the two settlements are given. The site was inspected by me long ago, and I'm of the view that this is a good place for Gaushala and the low-lying land for the settlement with de-reserving landless persons. Further, since Gaushala has already been delivered possession after realizing premium, I think there will be a lot of complications if allotment is cancelled and formal settlement not given. The institution ought to be encouraged. In these circumstances, I would recommend the settlement of both 75 bigha of land with the Gaushala and to settle 40 bigha of low-lying land covered by so-and-so with Konok Chandra Soikia and others who are landless and most deserving persons after evicting the undeserving persons who are now enclosed.
No, it has to be followed by providing similar measurement of land or compensating the loss. It is not there in speech. That's what I was asking.
Janu. It will actually pass the. My lord, I think there is requisite application of mine, my lord. When it says, it appears that only a small group of persons have been objecting to the Gaushala as well as settlement with Sri Konok Soikia and others. I find that plenty of land will be still left for VZR after the two settlements are given.
That's not the question, sir.
And
There's
my
a
lord will kindly appreciate
precise
it was done in.
Precise procedure provided in chapter 2, rules for allotment of grazing grounds.
Yes.
If that procedure has been followed, well and good. If not, the allotment is.
I think, my lord, for that, my lord, government will have to produce the record, my lord. I'm with the Gaushala, my lord.
We understand. So the allotment has been made to you.
Yes.
That has been set aside. Now on the ground that the procedure was not followed. You satisfy us. Why should we call the government to produce the record? The order has been found to be bad.
No, my lord, my humble submission
Yes.
is a substantial compliance of 95A has been made.
No, absolutely no.
Can you
Read
see, my
95A,
lord?
please.
If at any time Deputy Commissioner is of the opinion.
Yes.
that
So where is that opinion that wholly or in part not needed for the purpose it was allotted?
That's the para I read, my lord. The para I read.
This is before initiating the process.
Yes.
This is the final order of allotment. What you
No,
are
this is
reading,
not the order, my lord. This is how, my lord, the proposal was.
proposal
dealt
has been
with.
sent.
Yes.
So before that,
Yes.
the process for allotment was initiated on your application.
Yes.
Let's see that process.
No, my lord, the process culminated into this proceedings of my lord,
Yes.
5/2/72,
Hmm.
5th of February, where my lord, he dealt with
Mr.
the
Chaudhary,
objection.
please read before that your application and the following process.
I'm reading it, my lord.
Yes.
He shall publish a notice regarding proposed cancellation of the allotment,
There is a proposal.
hear objections and forward his proceedings together with his recommendation to the government for final orders.
It is not required.
Not required. There is no satisfaction.
And then governorship, I am approving the settlement, but not the other first because I cannot settle or land this.
Yes.
My lord, when the writ petition was filed, the basic plea was, my lord, that notice under 95 was not issued.
Hmm.
That was the premise. If
Yes.
Lordship will kindly permit me to place 2 paragraphs from the writ petition, my lord. My lord will kindly have page number 65, my lord.
Where is the order of de-reservation, please?
Yes, 101, my lord.
101, let's see.
It refers to that notice, my lord. Refer NRS 28766, 5272. I'm directed to say that Governor of Assam is pleased to approve your proposal for de-reservation of 75 bighas of land covered by part so and so, so and so, so and so for allotment to Gopal Krishna Gosala. As regards the low-lying areas of 40 bighas of land proposal for de-reservation for the purpose of giving allotment to the landless people, government regret their inability to accept your proposal in view of the new land settlement policy of the government. Unauthorized occupant or enforcement, if any, should be removed. So this is the final order, my lord. Connected records are written herewith by so and so for information. He will please be hand over land covered by the above document so and so. So my humble submission is, my lord, page 99 recommendation of the Deputy Commissioner. He has substantially complied with the requirement envisaged by Rule 95A, my lord. And the writ proceeding was instituted, my lord, after 41 years.
You are not doing anything on that. It was being used by the villagers as a grazing ground.
No, no, my lord, it is in
You
our
started
possession.
activity in
No,
2000.
my lord, there was a 145 proceeding, my lord. There is a 145 proceeding that your lordship will get at page 55. Where, my lord, the executive magistrate has recorded that the possession is in Kosala.
Granted without.
It is of 2011.
Then.
165 to the
Just hold on.
First is 84.
84.
It is 165.
Let's, Ms. Chaudhary, see page 84 first.
Yes, my lord.
Before any proposal.
The
Yes,
settlement
ma'am.
was already done. So
No,
the
it was a
entire,
formal, no, this was the initial order whereby the land in principle was allotted to us.
how could it be without de-reservation?
Yes.
That is what the crux is.
No, my
No,
lord.
no. See the date of this order.
In fact, this order.
So
was
a lot
kept-
settlement is
No,
made
this
even
or-
before.
This order was kept in abeyance.
Yes, so what?
Yes.
So that is vilified on the face of it.
No.
That is favoritism.
No, my lord. This order was kept in abeyance against us. Please come to page 87.
Yeah, we have seen that order, page 87.
Yes.
We have
So it
seen
was
that.
kept in abeyance, my lord.
But we'll continue at 2.
My lord.
Yes.
Lordship's indulgence, may I pray item number 35 and 36?
Yes.
May kindly be posted on some other day. I have some personal difficulties at home. Oblige, Lordship.
Persons have been objecting to the Gosala as well as to settlement with Sri so-and-so. I find that plenty of land will still be left for VGR after the two
That is not
settlements
the
are-
requirement of this provision. Provision says specific opinion not required for VTR. That is not a satisfaction. So,
Directly it is not there, but indirectly.
no, it is not. We can't read something which is not there.
Well, there's one more provision just for my lordship.
Of course,
Section 153(2), my lord.
Section 153. Section or rule?
Section, my lord.
Regulation.
Subsection 2 of 153.
Regulation.
Yes, my lord, regulation. At page 90, oh, the pages will not tell you.
153(2),
subsection 2, my lord. No proceedings under this regulation shall be affected by reason of any irregularity or omission in publication or service of any notice or proclamation thereunder, unless it is proved that some material injury was caused by such irregularity or omission.
So we are not going onto the aspect of non-publication of notice now. We are on the substance of the order. Whether the order is founded on the very essence of Rule 95.
My lord, I was only trying to submit for your lordship's kind consideration, my lord. Yes, the substantive requirement of law is the deputy commissioner must record or arrive at a satisfaction that de-reservation is permissible because it is no longer required. Now, will that purpose not be served, my lord, when an
saying that alternative land is available?
Yes, alternative lands are available by which the purpose can be achieved.
Towns grow by the day. Grazing lands are being encroached upon, eaten away. So this 317 bighas which is left as on date, hardly anything of that will be left. Be realistic about it. These are very liberal provisions. In Rajasthan, the provision is that you want to de-reserve even a single meter, reserve equal measurement for grazing. You can't reduce the area. That is what the provision is.
My lord, more or less land revenue laws are of the same all throughout the country.
We didn't find any such provision that the equal portion of land would have to be
That is
reserved.
not there in our regulation.
That's right. Those are rules of 2007, which have
my
been
lord,
framed in Rajasthan.
maybe when the regulation was made,
At
lands
that
were
time, the requirement was not.
abundant.
There was land in abundance.
Hardly any people were
This
there.
must be right in middle of Nagaon now.
Yes.
That's why they fight. We can fight.
But my lord, lordship, the purpose is
And
otherwise.
the community which is fighting the litigation, I know very well. You can expect me to have better knowledge about it.
My lord, my learned friend wants me to point out to your lordships, in the writ petition, my lord, they have annexed a document which is actually, the page 99 report that is dated, my lord, 5/2/1972.
File FIR for that. You are at liberty.
But my lord, another aspect was, my lord, they came after 41 years. My lord.
That they have explained why they have come after 41 years. All right, order judgment reserved. You have got anything to say?
No.
Nothing. Okay.
Although my lord, it was disputed in 1971 itself, my lord, the reservation was state. That time the reservation.
You have raised the dispute then.
Yes, yes, that time.
Item 44.
Is that review matter? No.
But the matter relates to selection of a junior assistant in a school. But I was the selected candidate. It was set aside by the learned single judge on the ground of that the marks given in the interview were not correct. Actually, the selection consists of written examination and interview. So far as the written examination is concerned, no problem. The petitioner did not make any problem out of it. Now, he says that in the interview process, he was given 0 mark.
The respondent, the petitioner, writ petitioner.
The writ petitioner. And that was interfered with by the learned single judge.
Yes.
Holding that the grading of the marks given in the interview process is not correct.
Not fair.
Not fair. That your lordship please to see paragraph 15 of the writ petition at page 96.
Order, sir. Judgment.
Judgment.
15.
Insofar as the stand taken by the respondent number 4 and 5 regarding the conduct of the petition in the interview. 4 and 5 are the, my lord, the people in the selection process. Selection committee members. Held on so and so is concerned, the court finds that the final merit list 2016 was prepared on so and so. Though the 4 members of the selection committee had put their signature, but none of the selection committee members made any remark to the effect that the petitioner had misbehaved with them, nor did answer their questions, or that he had left the interview process midway. As the final merit list dated so and so does not contain any such remark, the stand taken in the affidavit in opposition filed by respondent number 4 and 5 merely to bring an improvement by way of an affidavit is not
Yes,
permissible.
yes. So
In the
nothing of the
absence-
sort was reflected in the interview proceedings. Where the interview proceedings were recorded, there was nothing to this effect. So this was an improvement rightly observed.
Well, the question would come in whether the learned single judge.
Otherwise also, sir, it's a grade 4 post. Supreme Court has said no time and again.
Grade 3 post.
Grade 3.
Grade 3.
Right, okay.
Junior assistant.
Hmm.
It is the LDA.
LDA. Yes.
LDA.
Yes.
In that case, my lord, the question is that whether the courts below would be within their domain to scrutinize the grading of the marks.
When the marks given are 0, yes, of course. That raises a suspicion immediately. What was the reason? Didn't the candidate answer anything? Did he give wrong answers?
He
Why
has
0?
given in the affidavit in opposition, he has said.
What?
But that
Let's
he has
see your affidavit.
misbehaved, he has got corrected, got not given the correct answers, he had misbehaved, and
That is all an improvement. Apparently, then the interview board members are trying to favor one candidate. It's apparent.
but even that it is better. That whether it is in the domain of the courts below.
It's
to
not a court
look into
below,
the
sir.
matter.
It's not a court below. The learned single bench.
Right, second.
Please correct your language, please. Yes.
And secondly, my lord, he had appeared in the interview process.
Yes.
And whether he can take turn now and say that.
Obviously, he
the
didn't know what
given-
marks will. He had no idea that he will be awarded 0 marks. So obviously, he will challenge thereafter only. How could he have challenged it beforehand?
No, my lord, the question is, if one submits the jurisdiction of the mark of the interview committee, and the committee gives certain marks to the.
The
certain
allegation
candidate.
is that the committee members were biased. They did not act fairly. That is why the challenge is laid.
There is no question of bias. It is not laid down.
Unfair.
That it is unfair or it is biased.
Let's see their pleadings, please. Let's see their pleadings.
In the writ petition, my lord.
Yes.
It is at page, my lord, 15.
Yes.
It starts.
Is 21 paragraph 7.
Oh, paragraph 7.
Paragraph.
He stands first in the merit in return. How
the-
do I oust him? Give him 0 marks. Very simple.
No, my lord. The other candidates were also given 0 marks. 2 other candidates were also given 0.
So then the focus of the interview board was somehow to get one man in. Apparent.
44. Page 44.
Page 44, your lordship.
Let's see.
Even after giving him 10 out of 10, he scores only
It's
0.5.
only a remand.
Women.
Let a fresh interview be held. What is the problem?
That is the
It's
direction.
only a remand.
But I would like to place before your lordship certain decision.
Yeah, sure, sir. Definitely. 44, Mr. Nair. 0,
Page
0.
44.
Who is the selected candidate?
Number 2.
And what was the maximum marks in the interview?
10.
10.
10 out of 10. Wonderful.
And
No one else scores more than 3. This gentleman is a privileged guy.
My lord will see the difference
Yes,
after giving him 10,
44.5.
5, and I get 44 with 0. That was the idea. My lord.
Conscious effort.
Even if 1 mark is given, I'm through. My lord.
No, proceeding to the, proceeding to the, proceeding to the. But 1993 supplement 4 SCC 377.
Yes, please.
Supposing a candidate matter comes with a predetermined mind that I will teach the members a lesson and he commits certain things, he can be given 0 marks.
How many candidates were of that character in the interview proceedings?
That is not reflected in that.
0, 0. Number 1 gets 0. Number 5 gets 0.
And 8.
Number 8 gets 0.
Yes. There may be justification for giving
That
0
justification should reflect. It's a matter of public employment. Can't be on whims and caprices of the interview board. What was the reason assigned? Didn't the candidates answer a single question? Now you come out with a case in affidavit saying that he misbehaved. Then you should have noted it in the interview sheet.
In that case, my lord, every interview process,
Yes,
it is required to be
fair and transparent.
it is required to be noted in the remark column
Yes,
that why I gave 3 marks to each candidate.
not
and
not
7
that.
marks to get.
If a 0 is given, yes, their reflection should be there, definitely.
And the 0 is for his misbehavior.
And that 0 supposedly for misbehavior, then it was bound to be reflected. If you are not taken that plea in the affidavit in opposition, maybe the process might not be interfered. But since that plea is taken, now that vitiates the things.
1993 4 SCC
Yes, please read.
377.
Yes.
Copy those. Paragraph 13, madam.
Yes.
That has been quoted.
Page 97, my lord, the Honorable Single Judge has quoted that one.
Yes. As regards the rejection of candidates on the grounds they had misbehaved at the time of interview, were unable to agree with the High Court that the board could not reject a candidate on the ground that he had misbehaved at the time of interview. In the process of selection, the board is required to judge the suitability of a candidate for appointment on the post for which selection is being made. The board is entitled to take into note of the behavior of the candidate at the time of interview, and if it is found that the behavior is such as to render him not suitable for holding the post for which the selection is to be made, the board would be perfectly justified in rejecting him for appointment to the post. If the course suggested by the High Court is adopted, namely that the board may give 0 mark to the candidate who misbehaved at the time of interview, the result would be that the candidate whose behavior was such as to render him unfit for appointment to the post may have to be selected and recommended for appointment on the basis of the mark.
What is the ultimate direction in this case? Please read. Paragraph
Ultimately,
15.
Direction is, my lord, to
The
conduct
selection has been caused. Fresh interview has been directed.
fresh interview.
So that's what the direction is here. Face it.
In that case, also it was done.
It is the same.
Oh, yeah. Like we are. Second point, my lord, that he has I am instructed by my junior to place before your lordship the case law. Well, I am giving the citations already.
So
1990.
he's trying to ensure that you justify the brief.
So I listed that better.
Very fair, very fair. Yes, Mr. Nair.
My lord, only my case is that page 44. My lord would find the actual reason emanating therein. I made a challenge.
44.
Page 44 of the writ appeal. That's select list, my lord.
Yes.
Now, here, my lord, I secured highest in every component, And my lord, my total was 44. Even if I was given 1 mark, my lord, still the the appellant herein could not have caught me.
Giving one man 10 marks, the other is not getting more than 3.
And the highest thereafter is 3, my lord.
Yes.
And lordship would find that in the pleadings, in the records that were produced, in the select list or in any contemporary record thereafter, my lord, there was no such mention.
No such mention that
And
is.
my lord, what happened is they made this plea in the affidavit. We filed an RTI. In the RTI, my lord, we found that this matter was looked into by the deputy commissioner. It is without jurisdiction. The deputy commissioner should not have come in. That's what the honorable saying. But therein, the selection committee members had gone and made statements. We brought that on record, wherein they said that in a hurriedness, because we did not know, they were not in very prompt in answering, so we gave 0 marks. And it was a mistake. So that was the stand taken, my lord, immediately after this election. When it came to the High Court, it became misbehavior, my lord.
But that finding, my lord, as per paragraph 13, the Honorable Single Judge has said the proceedings before the deputy commissioner was wrong.
Yes.
It was without
But still
jurisdiction.
the evidence collected therein can be looked into.
No,
Proceeding may not be relied upon,
no.
but the evidence collected therein,
There is a confidential
the
statement.
High Court can very well look it in 2 to 6
The
to balance the equities.
Honorable Single Judge has said
Yes.
the confidential statement made therein also is vitiated. Paragraph 13 of the reply,
Yes.
of the judgment.
Very well. All right. Dismissed.
Much obliged. Sure.
Item 37.
Affidavit आ गया? Madam.
Lordship, we have e-filed also, Lordship.
E-filing क्या print निकालो?
We
You have a
e-filed.
copy with you, no? You have confirmed the order on 19th
Yes,
May.
Lordship, there is 3 days delay, Lordship.
Single minutes delay.
Lordship,
Article 22(5).
Lordship.
Not even a minute.
Yes, Lordship. On 14 to, he was arrested, Lordship.
Yeah, I gave it to, we gave it to them, the judgment morning.
We had given you a judgment in the morning.
Lordship, yes. I have gone through, Lordship.
So they have woken up after this order.
Pardon, Lordship.
Your officers have woken up of this after this order passed by the court.
Lordship, that I am not aware of, Lordship.
All right. This is a petition filed under article.
Lordship, the officers, they are also online.
Yes.
Lordship.
Who is there online? Mr. Secretary.
Yeah,
Officer
Lordship.
good name. Yes.
Lordship, I'm Shiladitya Chetty. I'm Secretary, Home and Political.
So you are dealing with the detention matters.
Now I am dealing with the detention matters.
Have
Yes,
you
Lordship.
taken the trouble of looking at Article 22(5)?
Yes, Lordship, in the recent order.
When did you join? When did you join the post?
This February, Lordship.
February. After February, there have been 3 judgments by this court. The first judgment was in the case of Shahrukh Ahmed. That was 24th February.
Yes, Lordship.
When you are dealing with such sensitive matters, this is the rather we would say conduct in which the detention matters are to be dealt with.
Lordship, you
don't even care to look the constitutional look at the constitutional provisions which are applicable to the case.
Yes, Lordship, we are looking into that, Lordship.
This is an empty formality you are doing. All right, pass the order of detention. The court will take care of the things. Why are we bothered? These are drug peddlers after all.
Yes, sir.
Why shouldn't we impose cost and direct you to pay it? Tell us.
No,
You
Lordship,
kept this man for behind bars illegally for 3 days. Why did you pass an order of confirmation now? Tell us. How
no,
could you have
Lordship,
done it?
Lordship, we base our total examination of the records then on the records submitted by the concerned SP, who initially moves the proposal. So
We are
we
not on the initial moving, Mr. Secretary. We are asking you, after the 3 months period had been completed, how
Yes.
could you have confirmed the order?
Lordship,
Answer.
we refer the initial order of detention to the advisory board, Lordship, as per the act, and then after receiving the opinion of the advisory board.
When was the opinion received?
Lordship, it was received on, as per records, it was received on 31st of March 2023.
All right. And the order has been passed on?
On 19th of May.
Did you even bother to see that what was the period the detainee had undergone?
Yes, Lordship, because of certain processes, it took us 3-4 days extra time, Lordship. I therefore plead to kindly consider the matter, Lordship, and we will make sure that we'll not
When was the,
exceed
just hold on.
Yeah.
When was the initial detention order passed?
So, Lordship, the detention order was passed in initial 11 November 2022.
So now
However,
you have exceeded the limit. Even the board's report is beyond the permissible limit of 11 weeks.
Lordship,
Now you have kept the detainee behind bars in excess. You should have confirmed the order in latest by 11th February. That's 3 months.
Lordship, may I plead, Lordship, this is 15th of February when the order was executed.
Execution is 15th February.
Yes, yes.
Where do you mention this?
Lordship, in the affidavit, it is mentioned.
And what took you so long to execute?
Lordship, I think that will be the responsibility of the concerned SP to execute the order. So,
You must have been in jail in connection with some criminal case. Yes. That is the reason. It is because of your incompetence a drug peddler is being set free. Is there any escape route? Can this order be sustained now?
Lordship, we will make sure that this.
You tell us, is there any way of preventing this order from being paused?
Lordship, kindly consider that as per the report of SP.
No, wonderful. Kindly consider. Overlook the Constitution. Throw it behind the windows. That's what you want in this in the attic. Have you read 22.5 even now?
Yes, Lordship.
What does he say? What does the provision say? Read.
And that, Lordship, from what I recollect of Article 22.4,
yes,
that any preventive detention should not exceed 3 months.
So,
unless it is confirmed by the concerned legal provisions.
Has it exceeded in this case or not?
Yes, it is exceeded, Lordship. Actually, we were basically, Lordship, it was a matter of 4 days, which should not have happened.
Does the Constitution give you Section 5 of the Limitation Act extend the period for confirming detention? Is there any provision in Constitution?
No,
Simply because you officers, the officers in the Home Department are incompetent, the constitutional provisions should be waived. That's what you want the court to do, right?
No, Lordship.
Detention cost. The detainee shall be set at liberty forthwith, if not wanted in any other case. No compensation in this one.
My lord.
That there the delay was significant.
My lord.
Deeply obliged, Your Lord.
Deep problem.
Item number 29, along with the item number 1 of production list.
Mr. Burgoyne, you made wrong. Who made a mention for the review? You made a mention.
Review.
Who requested that the review should also be listed here?
Review petition, madam. No?
Is not that one?
No, no,
Okay.
this is different.
Okay, right. So this,
What happened?
in production, there is some fresh matter listed. Which matter you listed in the production list?
This is a matter in the main list. Along with
Single bench matter. This is a single bench.
My lord, let me put the facts. After that, your lordship may look into it. What happened exactly?
challenging the rule of the Karbi Anglong.
My lord, exactly, Kavi Anglong. What happened, your lordship, is that before I go into the merits, my lord, why I had to make this mention? My lord, what happened? In the year 2021, 26 November 2021,
yes,
the petitioners were served with a notice under Rule 18.2 and 18.3 of the Assam Land Revenue Regulations for eviction. The petitioners were patadars. They have come from Nagaland, various parts of India. They were residing in that place for considerable period of time, and they are exercising their adult franchise and everything.
Okay.
Now, we came before this court challenging that rules, challenging that notification for eviction notices. Our ground was that due procedure was not being followed as per the regulation. I'm just coming in a factual thing. Now, after we apprise this honorable court, the landed single judge, hearing both the parties on the first motion day, subsequently on the second motion day, protection was granted to us, interim protection. After that, the protection was been extended time to time. Now, on 17/1/2022, your lordship, I apprised the court, the landed single judge, that Karbi Anglong Autonomous Council is not competent to issue, exercise the power under the
Assam rules.
Yes, exactly, my lord.
Okay.
To that effect, I filed an affidavit. And I filed an interlocutory application on 9 February 2022, which was registered as 391 of 2022. I put my grounds that it was beyond the legislative competence of the Autonomous Council. And since the rule has been challenged, that a particular Mikir Hill Land Revenue Act and the Amendment Act has been challenged in this matter, let this honorable court, learned single judge, in exercising of the power under the Guwahati High Court rules, let it be referred to the division bench.
All right.
After that, Karbi Anglong Autonomous Council, they filed an affidavit to that effect.
But why did you require? Why were you required to challenge the rules? Because their proposed action was under the Assam rules.
My lord.
So why were you required to challenge these rules?
What happened, your lordship? Why did they exercise that power? The question is that they exercise the power under the Assam Land Revenue Regulation by bringing in force of the power under Mikir Hill Land Revenue Act or Karbi Anglong Land Revenue Act, which was beyond their competence. Now, what happened, your lordship? When the matter was being heard, then the court felt that instead of looking up the matter in the IA for referring to the division bench, why don't we move an application for amendment? So subsequently, amendment application was filed, which the KAC has not objected, and the matter, this division bench, the matter came up.
Okay.
Now what happened, your lordship?
This is a fresh writ petition. This is not an amendment you have brought in.
My lord, because in pursuance to that order, we have filed this petition.
All right.
Now what happened, your lordship? The writ petition, that single bench writ petition, which is that is 7211, your lordship, that has become basically state because of this virus is challenged here. Normally, that the precedent is there. Now what happened, your lordship? In the meantime, what happened? There were two orders. There were two orders have been passed by this court because
in which matter?
In this 7211, my lord.
SB writ.
Yes, SB writ.
Yes. What are the orders about?
Contempt petition 100.
Which order?
My lord, 18/1/2022. 18/1/2022. The order to the. Well, lordship have it.
Yes.
I will read the first, second para, my lord.
Yes.
I will read the second para, my lord. Mr. S. Burgwell, learned counsel appearing for the petitioners made an unusual appearance in the first part of the day, while the other proceedings of the court were going on, stating that the officials of respondent KAC visited the land at Lahore Region Block number 3, Moja Borjar, under KAC involved in this case, and that the order under section 144 CRPC like situation has been made in that area. Mr. S. Burgwell also made a submission that he has already talked with the Joint Secretary Department of Revenue KAC as well as the Deputy Commissioner Karbiang. As the matter relates to eviction of encroachers from government land of KAC, the court considered to hear the submission of the petitioners in the second half of the day. As such, the present writ petition was called upon, though not listed on the board. The concerned standing counsel KAC was accordingly informed by the court. What I am trying to draw, my lord.
This file was called from the office, or was it reserved for orders earlier in that court? When it was got listed, and you made a mention.
My lord.
The file was in the registry.
It was in the registry.
Okay.
It was in the registry. Why I'm referring to these orders is that, my lord.
Yes.
My lord, when there was an order for stay in the eviction process, they, behind the back, they broke the houses, they demolished a certain portion of the residence in that area. And that is why these two orders, 18/1/2022 and 29/1/2022 orders have been referred, because they gave an assurance that they are not going to do anything. But your lordship will kindly come to 31 January 2022 order. 31st January 2022.
Yes.
In the last para, my lord.
Yes.
If agreed by such eviction, any such eviction drive carried out by the respondent in the KAC yesterday over their patta land, violating the court's order dated 23rd December 2021.
May file a contempt.
File a contempt.
Okay.
So we file a contempt. Our contempt was filed because the villagers, they were not aware who is the responsible person. We filed in the name of the officers who executed order. Now, in that contempt, the KAC has objected that because of section 12 of the Contempt Act, an individual person should be there. I will argue to that effect differently, my lord.
Yes.
Why
contempt is not before us.
Now that is not before us.
Yes.
But why I'm putting all this thing is that today morning I was appearing for this matter because they are not yet filed their affidavit. That was that. But why I mentioned this thing is that today morning I got a message from the authorities, from my petitioners, that and 144 order has been passed saying that they are going to carry out eviction.
Okay.
That prompted me to put before this honorable court.
Okay.
First, second thing, your lordship will appreciate the place where the place is situated. It is just bordering the state of Nagaland. The people who are staying are various tribal people, communities of different, and situation may turn. What is happening, my lord? It may turn very bad. On this apprehension, my lord, those two orders which I have referred of 18 January and 29 January.
Let's ask them whether they are proposing.
My lord, I have got a copy. I will just put it, your lordship. I just got a copy.
But it is for the same area.
Same area, your lordship. Kindly see. Kindly see, my lord.
Let's see.
These are the two communications given to me. Print out I have from WhatsApp.
Yes.
And these are the two 144 notices.
Yes.
For me, where is the print out?
Yes.
My lord, that one set which I have given is there, your lordship. This is a communication sent to me by my client,
Hmm.
my lord. You have not taken out the paper for me. Yes.
Block 3, Lahore, that's the area.
Good morning, sir. We are issued notification that KAC will be carrying out eviction drive at our village on 3rd and 4th June 2023, and that order of 140 CRPC has been issued in the areas by the DC of Karbi Anglong, Assam. Please do the needful. And this notification. Now your lordship will kindly see the notification 144.
Yeah, we have seen it.
Your lordship, how they
My notification was issued by the deputy commissioner, my lord. The eviction drive, proposed eviction drive is to be carried out on 3rd and 4th June.
Lahori Jan,
Lahorijan area. my
same land,
Not
where
my-
there is a stay of this court.
There is stay, my lord, in respect of the periodic patta, my lord.
No. He's misleading, my lord.
Not,
I must say.
Mr. Counsel, keep your commissioner present tomorrow.
Deputy
Keep your commissioner
I'm not
present tomorrow.
representing The deputy commissioner, my lord. I'm not representing the deputy commissioner.
No,
Deputy
we will
commissioner
direct
is present.
that she shall remain present. She shall remain present tomorrow.
Before that, my lord, I just only point out, my lord.
Yes.
In this particular writ petition, notice was issued on 23/11/2022.
Yes.
And a copy of the writ petition was served out after 6 months on 23/21/2023.
Yes.
That as per the High Court rules, they have to serve the notice copy on within 3 days. They have served copy.
All right. So on this ground, we should dismiss the
No,
petition.
no, I am not asking that, my lord. So, my lord, that we have not.
Simple question is, sir, there is a stay of this court. How does your officer dare issue that notice?
My lord, there is no stay, my lord, at all by submission. my
All
lord.
right, let's see.
My lord,
Let's see if there is a stay or not.
my lord, on the periodic patta, my lord.
Let's
Not
see.
from
My
the
lord,
government.
kindly come to the order dated 23/12/2021.
Since the orders passed by the principal secretary, KAC dated so and so, specifically provided not to proceed with any eviction or drive. So you assured that you are not proceeding.
My lord, that may be taken as surprise, but the copy that you was not mentioned before that will be taken up. That copy I don't have, my lord. Without looking into it, my lord, it is difficult to submit that what is the order, my lord. They have
All
not
right, give a copy.
courtesy- they have not a courtesy to mention it in the morning also that matter will
Why
be
should
taken up. So that
why should I mention your officer should be here?
No.
You are doing things behind my back.
if the case is
Hold on.
listed, my lord, unlisted.
You
case
get
is
a case
unlisted.
listed on a special mention, you are required to inform the other.
My lord, that is the point, my lord.
My lord, I'm sorry for that, but the thing is that your lordship, the record will speak with my folded hands.
Mr.
They are doing
Counsel,
certain acts which
the
is
order
behind the back.
dated 23rd December 21. The
I don't have,
respondent's KAC
my lord.
shall not proceed with the eviction process pertaining to notice issued so and so.
My lord, that notice that has been elapsed, my lord. That has been in section 18(2) notice that has been withdrawn, my lord. And so, my lord, that. notice
So
has been
the
in
stay comes
2021.
to an end by your withdrawal.
My lord, that notice withdrawn, that eviction, there is no eviction on
Mr.
that.
Counsel, this is a subterfuge. That's a device to avoid this court's order.
in-
Don't force us to that position. We'll put your orders, officers under suspension right now.
My lord. It is not.
Don't compel this court, please. This is a way devised to avoid this court's order, to flout this court's orders. All right, we have withdrawn that notice, sir. So what?
My lord, in 2021, then when the rule 18(2) notice was issued, my lord, that was withdrawn. My lord, thereafter, my lord.
There was a stay on eviction drive. Your officers need to know they are dealing with the orders of the High Court.
My lord, that eviction has already been stopped. That has been, my lord.
So now every day you issue one notice, we stay that notice, you withdraw the order and then pass a fresh order of eviction. You mean to say, you want to justify that kind of action?
Now, my lord, on what is the, my lord, land that is required to be, will be evicted on 3rd and 4th, that instruction. My lord, that I have the instruction of telephonic instruction that from the government land, there is a proposed to be eviction from the government land, not from the periodic patta land. Lordship may record my that submission only, my lord.
All
That
right.
My
What do you
submission
say?
from the government land, no periodic patta, my lord. That is my submission, my lord. That has been decided by the executive committee of the autonomous council to evict the encroachers from the, my lord, government land, not from the periodic patta land, my lord. That is my instruction. my
Your
lord.
lordship, let us take it, what my learned colleague is saying to be true. Let us refer to the 144 orders.
Yes, let's see.
Whereas in view of the proposed eviction drive to be carried out by the Authority of Revenue Department of Karbi Anglong Autonomous Council, DIFU, on 3rd and 4th June 2023, against the illegal and unlawful encroachers at Lahorijan block number 3, areas under Borjan Moja of Bukazan subdivision of Karbi Anglong district. Now, my lord, what is the writ petition about? Who are these petitioners? They are resident of Lahorijan block number 3.
Mr. Borgoin, there can be other lands, common lands in that area, which is under encroachment. He is making it clear, no patta should land, the owners will be disturbed. What is the problem?
My lord, let me, for my past experiences in this matter.
Yeah, we understand that.
My
Yes.
lord, what they are doing, let me complete, sir, let me complete, please, let me complete. I don't make this type of submission, but you're prompting me, please, with all due respect. My lord, what my past experience, what I said, when there were 2 assurances given to this court on 18/1 and 29.
That we understand. They are trying to play smart.
My
Issue a
lord,
notice,
now,
get a stay, withdraw it, do a fresh proceeding now.
what they are doing is that they are
Yes.
creating a panic environment in the entire area because they have not issued notice.
Right now, we are staying any kind of eviction drive in this area. Then this order is stayed. Communicate to your authorities. All right. The matter has been listed on a special mention made by counsel, Mr. Burgoyne. The writ petition calls into question the legality and validity of rules so and so of the Karbi Anglong Land and Revenue Act 1953 and the 4th Amendment 1973. And so also the notices issued to the petitioners herein who are having periodic pattas over plots of land in the Lahorijan area.
Lahorijan, yes, ma'am.
Lahorijan block 3 area of Karbi Anglong Autonomous District. Post op. The petitioners have alleged that previously also, similar notices were issued and the notices of eviction were issued. Thereupon, they were forced to rush to this court by way of writ petition number 7211 public 2021. Post op. Despite the stay orders passed in the said list, writ petition, the authorities of KAC, started demolishing the houses constructed by the petitioners on their patta land. Thereupon, contempt proceedings have also been instituted. Now, under the garb of removing encroachers from government lands in the very same Lahorijan block number 3, the petitioners are again apprehending that they will be dispossessed from the lands over which, they hold pattas. Stop. Then counsel, Mr. J. Chutia, representing the KAC, submits that he has not been provided any details of the order passed by the Deputy Commissioner, District Magistrate, Difu. However, on
Now, that order, my lord, I have.
You are having-
Challenge before the singletons today, my lord.
There's more writ, one more.
No, challenge.
Yes, my lord, that is the case number 2.
I have no challenge, not this petition.
You don't unnecessarily get off your handle.
My lord.
It's not like that.
There's already a writ challenging this order.
My lord.
Notice.
Yes, today, my lord, in court number 7, my lord, WPC 3120/2023 was filed by another person challenging that order, my lord. Today before the.
He submits that another litigant has challenged the order dated 26th May 23 issued by the District Magistrate Difu, on the strength whereof, the petitioners claim to have a reasonable apprehension that they too might be ousted from their plots. Mr. Jutia submits that he has received instructions from the authorities that no person having periodic patta will be evicted under this notice. Be that as it may, comma, looking to the past happenings which are available in the file of writ petition number 7211/21, comma, we feel that the apprehension of the petitioners is not unfounded. Thus, comma, as an interim measure, comma, we hereby direct interim measure until complete facts are not placed on record, comma, we hereby direct that effect and operation of the order dated 26th May 23 shall remain stayed till next date. And no eviction drive shall be undertaken under this order.
My lord, there is one more humble submission, your lordship. If your lordship can see who they place, these people, the petitioners, they have apprised me that there is a local newspaper of the Karbi Anglong Autonomous Council news channel. They're publishing news items, which is almost threatening the harmony of that area. My lord,
It's not there part of the record.
my lord, at least an observation.
Don't put in extraneous material.
My lord.
Re-notify. When will
just
you?
only point out, my lord, that that local area, my lord, that area, that is the my lord, land acquisition process is also there, my lord, for that land is required for the defense purposes and ministry.
We are
owns
not,
that
we are
particular
not
area, my
on, you are on encroachments. We are not on the question of if you are proceeding legally for acquisition, we are not interfering in that.
lord. This program, my
No,
lord,
this is not.
encroachers are also not allowed to be
No, no,
evicted,
no,
my lord. That is the point, my
No,
lord.
no. This
Whether-
order specifically reads encroachers.
That is the, my lord, order only issued by the only for 144, not by us, my lord. They promulgated 144 for that.
In Land Acquisition Act, there is no eviction. It's a lawful takeover of the land after providing compensation. Don't try to bring those proceedings here. And tell your officers they have to behave. Otherwise, serious consequences may follow. This is apparently high-handedness, apparent high-handedness. Who represents the district magistrate?
District magistrate is the government, my lord. I'm not representing the DC, my lord.
Land Council, Mr. So-and-so puts in appearance on behalf of the district magistrate is a party.
My lord, yes, my lord, in the writ petition, he is a party.
District magistrate.
My lord.
Yes, Guardian. Copy of the writ petition shall also be provided. Why did you provide the copy, Mrs. Burgoyne, for so long?
My lord, what happened, your lord? Yes, your lordship, what happened?
My lord, to submit.
My lord, what
that, my
happened?
lord.
There is
That
a
the point.
personal difficulty was there. From November last year, my father was not keeping well and he passed away in December. And so I was busy with all those issues. So my lord, it was not a deliberate one. But we have filed a writ petition, my lord. This writ petition on, we filed a writ petition on 29/10/2022, my lord.
Notice was issued in November.
And
You didn't give a copy.
On 21.
He is justified in saying so.
My lord.
You are coming to the court, you are making fresh filings.
My
Don't do
lord.
like this. Re-notify. When will you complete the instructions and come back?
Friday,
Day after tomorrow.
day after tomorrow.
All right. List on 31st, 1st June. 1st June will be Friday. 2nd June.
2nd June is the second June.
2nd June. Yes.
Huh? Yeah.
Are you sure that you will be able to get
My lord,
instructions?
get the instructions.
All right.
My lord, there is a one thing is that both the writ petition, this 7, which is pending, your lord, 7498.
Yes.
In that also they are supposed to file the reply.
There is before the single document.
That is before single bench.
No. That is 7211 is before the single bench.
Yes. File of writ petition number 7211/21 shall be listed before the single bench.
My lord.
Hold on. Okay.
Oblige, your lordship.